Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun, enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Meshegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know, cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning, my friends. Thank you so much for coming to hang out with me. Today is Monday, April 14th of 2025, and we're back in Dedham this morning. We're back in Norfolk Superior Court. I am told that Karen Reed's team is going to try and pick 2 additional jurors today. They already have 16 jurors. They need, maybe they're shooting for 18. Opening statements are supposed to be tomorrow morning. I don't know. Are we ready for this? Are we ready to do this all again? I feel like it can't possibly be starting again tomorrow, but everything is being done in secret now because there's a gag order, so we really don't know what's going on. Happy birthday, Kale. Happy birthday to Kale, everyone. Thank you, Kale. Happy birthday. So glad to spend your birthday with you. Sassy Vice 420. Can't remember. If you know, you know. Easter's on 420 this year, which is interesting. I don't know how often that happens. So Jess Machado is on the standby line for court. There is a standby line. There's a lottery system this year for media tickets. And so media tickets, like this is some sort of event, which it really is. It's a spectator debacle is what it is. But I don't know who's supposed to be in the courtroom today. I think because Christina Rex and Ted Daniel were in the courtroom last week that they're not in the courtroom this week. So I don't know who else is live tweeting, but here's the hot tea already this morning. Jess Machado has seen in the courthouse, spotted Craig Bates, man of the tiny desk. He's back. He's in the building. Craig Bates is in the building. Who's more excited than me? We love Craig. He came on the show one time. Those of you may remember him from sitting at the tiny little desk inside the courtroom. He's the AV squad for the Karen Reed defense team, and the judge would not allow him to sit at defense table because the table's too small, Mr. Jackson. And so he is forced to sit with his very tall, maybe 6'2" or 6'3" legs at this little tiny, it looks like a TV tray table. Like, in the olden days when we had the TV dinners in the tinfoil Hungry Man Swanson dinners, and everybody had a set of 4 of those TV tray tables, and some people still have them. AV Daddy. Yeah, somebody said we stand Craig. We stand Craig. So I don't know. Does anybody know who actually is in the actual courtroom today that may be live tweeting? Hey, Hankersore has been here for 12 whole months, and I'm assuming that's a new username because I think Brennan hasn't even come upon this channel. He's not graced us with his presence since until the last couple of months when he was hired as the hired gun to come in for Norfolk County DA's office to try the retrial of Karen Reed because, they had to go outside the office to hire somebody. They had to get a guy. Not only do they have over 50 attorneys on staff, but, they had to get a guy and pay him like $250,000. So Hank Brennan is here. And thank you, Hanker Sore, for being here for a year. Tracy says, how can opening statements be tomorrow if she hasn't decided, undecided motion still pending? They could drop today. She can do whatever she wants, but we could get some decisions today. And we likely will. There's not that many outstanding motions. Hopefully she's going to say something in open court. Maybe they'll have some argument or something. We'll get something a little more interesting than what we've been watching since April 1st, when this started, April Fool's Day. So it's been 2 weeks since jury selection started. But I think they've only been picking for, I don't know how many actual days, because there were some weekends in there. Friday, they were off. Every day's a new day. Hands Solo Cups is here. And that's a new name in honor of Free Karen Read number 2. Oh, is that Midnight Mike? Midnight Mike, is that you? Oh, thanks so much for your super chat. I don't know. What say you guys? Nick Rocco says they're now saying Wednesday for opening statements. Okay, I'll allow it. I guess we'll find out. Okay, Nick Rocco said court will probably start Wednesday. I mean, I guess if he's the face of Court TV for the Karen Reed team, that he would know, but we'll see. Okay, Broken Baker said that Aiden said that statement. Okay, like, this is not a game of telephone until I hear it from an actual source. I'm not going to be reporting it to you until I know for sure, until I see an actual source reporting it, like maybe the judge. But there's a lot of rumor, speculation, and we are a panel. We're a panel. We're a channel based on facts, because that's what we do. Documents, court proceedings, and we like to base it on facts. So we'll see. I know that Friday's Good Friday. Court's closed this Friday. And so if it does start Wednesday, that's only 2 days of trial until we're into next week already. So Lana's watching the docket. I'm watching the docket too, Lana, and so far nothing has popped up, although I did find some little notations in there, like, the decision to allow the Alberts and the McCabe's to come in for closing. That sort of slid by. Maybe you did report on that, Lana, but I didn't see it. It's just a notation in the docket. She probably scrabbled on the bottom of the motion. And am I related to the Little on Karen's team? No, I am not. I am not. Straight up news. That is the straight up news. I am not related to Elizabeth Little. It is a very common name. So we've got Boston 10 up. We'll see what happens when they start. Maybe it's going to be the same old jury selection spiel, followed by the alphabetical list of witnesses by first name. So Aiden Carney is number 1 on the list. I'm surprised she doesn't say Aiden Carney, a.k.a. Turtle Boy, but she doesn't. EJ's beard is here. Happy Monday. My daughter's officially enrolled in engineering physics for the fall in Boulder, and I'm wearing my gear. Sco Buffs. We have an emoji for that. Sco Buffs. Yay. Deion Sanders has renewed his contract, I think, through 2029. So I'm a proud alum of the University of Colorado, Boulder. And so I love that for your daughter. And they have an amazing engineering program. And also did you know that University of Colorado has graduated more astronauts than any other university? Isn't that interesting? And Mass Dad is here and watching the docket all day. So don't worry, we're not going to miss a thing. Thank you, Mass Dad. I thought opening statement wasn't. I don't know. Sarah Lee, has not been confirmed. It hasn't been confirmed. There's rumor, but we like to base it on facts. So we're just going to wait until we hear it from the horse's mouth, or Lady Macbeth's mouth, as it were. Hi, lady Zelda Kelly. Thank you so much for your super chat and for thanking me, and prayers for Karen. Agreed. Prayers up. I can't imagine what it's like to have to go through this again. John O'Keefe was not hit by a car. If you watched my show on Saturday night, Nurse Kim came on my channel and we did a whole show. We went over Dr. Stonebridge's testimony. She is the doctor, the pathologist, who examined John O'Keefe's brain after it cured for 10 days in a jar. And she has all of the information. And she told us, without telling us, because she wasn't even cross-examined by the defense, that John O'Keefe was beaten to death. He was beaten to death. Multiple fractures throughout his entire skull. Brain bleeds here, front, back, both temples. Yeah. How many seconds will it take for the Commonwealth to say Turtle Boy? Yeah, I don't know. What's the over-under on that, Mike? What do you think? And tomorrow's Melissa's birthday. Happy birthday, Melissa. Oh, what a gift it would be if this trial was to get dropped. Yeah. Let's ask the Magic 8 Ball what the chances are of the trial getting dropped or charges being dismissed before trial. And it says, cannot predict now. All right. Well, that's, I mean, Magic 8 Ball is saying there's a chance, but I would say the chances are slim and none, and Slim just got on the bus. So that's just me. And Brooklyn Janet, thank you for your super chat. My heart breaks for Karen Reed. Such an injustice done to this woman. Yes, I know. I know she could be any one of us, and that is what is the really, really scary thing about this, because when you get right down to it, John O'Keefe was not hit by a car. And so the reasonable doubt is just so overwhelming. Charles Argo has been here for a month. If Bev changed the list, it would be X. If Bev changed the list, would be X Trooper at last. I don't know what you're trying to say, but it's by first name, and in fact, not really, because the troopers are all in the T section. So it says Trooper Michael Proctor, but that's in the T's. Then you've got Dr. Marie Russell in the D's, not the M's. And then other doctors are listed by their first name. It's Fakakta. It's upside down, inside out. But what else would you expect in the Narnia land that is the courtroom of Lady Bev? Lady Macbev, as we call her, because this is Shakespearean in nature, isn't it? Isn't it, though? Isn't it, though? Funk, okay, are you calling me out on my facts? Well, maybe when I went there, they were number one for astronauts. So at one point, they graduated more astronauts than any other university. But thank you so much for coming in and correcting me. I don't know where you got that information, but it's too early in the morning for that. So the white letter written by the other audit company was fire. Wow. I was hoping people from the industry would comment, but this is even better. White letter is basically death by peer review. Yeah, I saw something about that in my, inbox or somewhere throughout the social media world. I don't really know what that was. I think it was another company who had bid on the job, and they were saying that some of the stuff that was in the audit shouldn't have been in the audit, and that, I don't really know. I can't really opine on it. So don't send it to me now, because when people inundate me with emails during the live stream, it freaks me out. Please don't freak me out this morning. I'm already tense enough. There's already enough tension going on here. Freddie York, given that nobody's allowed to bring up the first trial to the jury, how does the Commonwealth get around the obstacle of bringing in the evidence that the defense paid the crash daddies after the first trial? Well, it has been ruled that they are allowed to talk about how much the witnesses were paid for voir dire. And so that is what they're allowed to ask. She has said that they are not allowed to be told that they were hired by the FBI. That also has been quietly ruled on. And there's just a notation in the docket for that. So they are allowed to talk about a prior proceeding. They're allowed to talk about voir dire payments, but they're not really supposed to know that there was a first trial. But look, anybody who lives in Norfolk County, if they don't know that there was a first trial in the Karen Reed case, then they're living under a rock, in which case I wouldn't want them on my jury anyway. So there's that. But Proctor isn't Trooper anymore and isn't on the list as Trooper Proctor. He actually is on the list as Trooper Proctor. He actually is. I have the list. Would you like to see it, beautiful messy ball? I've got the list right here. It's the combined Commonwealth witness list. So he actually is on the list as Trooper Proctor, unless there's been an amended witness list filed. But I'm pretty on top of it. So I imagine if there was one, it would have been filed, and she's been referring to him as Trooper Michael Proctor every single day. So let's take a look. Nothing's happening with that camera anyway right now. So here you go. This is the combined witness list, and you got to wait for the T's. Oh, Sergeant Yuri Buchanek. See, the sergeants are under the S's, but some of them are SER and some of them are SGT. So that kind of screws up the alphabeticalness of it all. And then look, there's Trooper Michael Proctor in the T's. So there you go. There you go. That's how they did it. Maybe you're saying they should have done it a different way, but nope. They didn't. It should be under D for disgraced. You know what I'm saying? It should be disgraced trooper, or even D for dishonorably discharged trooper, ex-trooper, dishonorably discharged former state trooper, Michael Proctor. And, by the way, I remember how and we played it on the channel. So do you remember how his wife and his sister went on television the day before he was terminated to make a family statement? And they were very upset, and they made a family statement, Courtney Proctor and Elizabeth Proctor. And then when Judge Cannoni's decision came out, where she refused to dismiss the case, in which she completely blamed Michael Proctor for not turning over all the Sally Port video, and that was her excuse for not dismissing the case, because Proctor, why didn't the family give a statement then? Like, how did they feel about her, all of a sudden throwing Michael Proctor under the bus and blaming him for the failures of the Commonwealth, and then saying, well, it's no big whoop. It's no big whoop that he didn't turn over all that Sally Port video, because there's no prejudice, because she gets to have another trial. Isn't that fantastic? She gets to have another trial. What a gift. What a gift. The prejudice was, the first trial, in which none of those videos were turned over, and in which perhaps she could have been acquitted. Boiled Frog 61 is here. Thank you. Let's all hold each other up. Let's all hug each other like a group hug. But I'll allow that too. Thanks for tuning in from across the pond. And look at Letter O's by Better O is here with gifting another membership. Yeah, and by the way, where's that motion? Where's the decision on Aidan Carney's motion to dismiss in his case? And where's the decision on whether or not Aidan Carney's going to be allowed in the courtroom, or if he has to be sequestered like the other witnesses? We don't have that decision. And we don't have a decision on Garrett Wing. So he's my guy. I love Garrett Wing. What do we know about him? Nothing. Because, why should anything be ruled on in a timely fashion? Why should the defense know the case that they're trying until, the very, very, very last minute? I know, and me too. It gives me like anxiety to look at that list. It's not the juror list. I know what you're talking about. You're talking about the witness list. But yeah, or the witless list, as I call it. She says, I'd like to send them the rules for filing alphabetically, including names, titles, etc. Yeah, no. This is, you're not in the real world here. It's just a big joke, and we're all just living in it, We're all in on the same joke, right? There's 3 Thomases on the list, and there's like 5 Bryans on the list, because if you live in Massachusetts and you were born like in the 60s or 70s and you don't know someone's name, or they were born in the 60s or 70s, just call them Brian. And you have like a 70% chance of getting it right. Right? A lot of Bryans. Brian Albert Jr., Brian Higgins, Brian Lachlan, and Brian Wanless. Oh, so there's 1, 2, 3, 4, 5 of them. Brian Loughran is also known as Lucky Loughran. He's the plow driver. Thank you, Midnight Mike Han Solo Cubs, for gifting 5 memberships. You're amazing. And AJ's Beard became a member. Welcome. And to the 5 who were so randomly gifted by YouTube. Welcome. K-Wags is also Aquarius. Aren't we awesome? Thanks for being our voice. Thank you for being here and watching, because otherwise I would just be voicing my aggravation into the closet and screaming at the television. So no, really, thank you, K-Wags. Each and every one of you. What are we going to do? I mean, it's still even wild to me that it is even going to start this week, if it will. She did tell the defense they were allowed to renew their motion for an adjournment if the jury was picked before April 28th or April 25th. So we don't know yet if they're going to renew it. They could, but here's the thing. How do you pick a jury, and seat them potentially by, say they're all done today, and then ask them to go 2 weeks and just sit at home and wait without watching social media, without reading anything on the news, without Googling anything about this case? It's virtually impossible. I mean, you can instruct them to do that, but would they? You tell me. You tell me. I don't know. Yeah, I can't wait. This will be interesting too. Love to see how the police show the Sally Port reversed or original way in this trial. Well, I mean, they say that it records inverted, so they can't now alter it to be the right way, right? So it'll be interesting. We'll see. Yeah, 8 women, 8 men is what they have right now, and I think they're looking for 2 or 3 more. And I don't know how many are being called in today, so let's see if Jess Machado got off the wait list and is in the courtroom. Let's see. The plan is to seat 2 more, it says, and it's not uncommon to lose a juror overnight, so let's see what happens. Yeah, that's happened a couple of times where they've had people selected and then they've had to, excuse them after they were already chosen, so maybe they found out something on social media about them. And, so we'll see. We will see. Yeah, Bev says there's a new trial. Who knows what she comes up with? I agree. Ted Daniels, no, Ted Daniels is not in this week, and I also do not think that Christina Rex is allowed in because she was in last week. So they get a week at a time, and it's some sort of random lottery system. I don't know how they do it. You know, is it like Jim? Is it like Clerk Jim putting a couple of bingo things in a drum and then pulling them out and not showing them to anyone? Liz loves the law. Thanks for being our voice of reason. Well, I try. Somebody's got to do it, right? I'm happy. I'm happy to take up the cause and the job and talking you guys off the ledge. Beth is here. She gifted a membership. Thank you, Beth. The rural juror. I can't believe we made it to this week. I kind of hope Alessi crosses Jen McCabe since Jen hasn't faced him. It would be entertaining to watch. I mean, I don't know for sure who's doing what, but I'm pretty sure that Alessi's forte, well, I know that his forte is expert witnesses. And so I don't think he's going to be examining the lay witnesses, but that's just what I think the strategy would be if I was on the team. But I think Alan Jackson knows what he's doing. And I think that they've got to be a little tougher on her this time. And I think we're going to see it. It's going to be entertaining. But Alessi's jam is expert witnesses. Monty Python's Life of Brian, the Canton edition. Yeah, that's right, Charles. I agree. Thanks for tuning in from South Africa and for your super chat. And Real Cat's Quilt became a member. Good morning. And I already addressed that one. And Snark Tank. It is Snark Tank night. Where are you? Where are you, Jules, that it's nighttime? Free Karen Reed Cupcakes versus Skullduggery. Twilight Zone 913. Watched Turtle Boy show last night. The crazy differences between both my shows and thoughts and opinions is fun to watch. Between our shows. But the respect that he has for you is great to see. Oh, thanks. I don't know. I didn't watch it, so I don't know what you're referring to. But if he said anything about me that wasn't nice, I don't want to hear it. Yeah, and I hate that, by the way. Please don't. If you're going to email me, because my email's in the show notes, and like that's cool, but I don't respond to all emails, although I do read them. But please do not send me mean tweets about me that people like. What is the purpose of that? That's like a girl in high school being like, you know, that so and so hates you. This is what they said. Like I don't. I'm not on Twitter for a reason, so just like think before you hit send. I mean, just out of like courtesy. Thank you. Jenna says, Mel love my Free Karen Reed sweatshirt. So comfy. Oh, that's awesome. That's awesome. Which one did you get, Jenna? Did you get the I went to Cancun with Melanie little one? Your BFF is in the pool this morning. In the pool? Like the swimming pool or in the media pool? And if it's the media pool, tell me who it is so that I can, if they're live tweeting, let me know who we could be following, Nicole. Thank you so much, Nicole Holban Accounting. I'm guessing she's a CPA. Yeah, Turtle Boy does like me. I know. I had to segue into the mean tweets, emails that people send me. Like, why? Why are you sending me that? I don't want to see that. Oh, in the juror pool. Oh, in the juror pool. That's interesting, Nicole. Oh, Nicole, you probably should not be here in the chat talking about that. Because do you guys remember during was it the Maya trial? Wait, no, it was the Ashley Benefield trial. Somebody was in a chat like Law and Crime saying my sister's on the jury. I mean, your friend's just in the jury pool, but my sister is on the jury, and she said that they're leaning towards guilty on manslaughter, and it was Ashley Benefield. And after the trial, there was a motion about that, and they were like trying to find out. It was who was it, you guys? That hoodie guy. It was that hoodie guy. Yes, yes, Brittany. Please don't put any names in the chat. Don't be a hoodie guy. That's what it was. Team Brittany is here. Good morning, Lovey. It was a guy called That Hoodie Guy, and he was in the chat, and I think it was on Law and Crime, and he was saying, my sister's on the jury, and she says, here's what's going on in the jury room, and they almost had that verdict overturned, but that judge down there in Florida was not having any of it. What was that judge's name on the Benefield trial? I can't remember right now because we handle so many cases. Yes, quizzical girl. The defense does have the right to ask to see the numbers that were picked out of the barrel. When on the show that I did on the Turk verdict, I showed both videos side by side or one after the other, the way it was done in Karen Reed's trial, where he picked them out of the thing, Jim, and he kind of put it in his hand and then threw it on the desk and then said, jury number 3. And the way it was done in the Turk trial right next door with another judge and another clerk in Norfolk Superior, how Margaret, the clerk, put all of the numbers in front of her on the desk so all the attorneys could see that all the numbers were going in the bingo drum. She put them in the bingo drum. She spun it around. She pulled them out and she held them up for all to see the numbers. It's very, very different. They do have a right. And I can't recall if they asked and something was done sidebar, or somebody said it sounded like Jim just took those 2 that he pulled out as alternates and threw them right back in the drum. I cannot confirm or deny because I was not there, but that is that. Michelle, being Turtle Boy said he'll plead the 5th. Do you think the Commonwealth would now call him so the jury will draw a negative inference against Karen? I don't think they were ever going to call him in the first place, Michelle. I don't think they ever were going to call him. I don't think they ever would call him. He's a loose cannon. He's a loose cannon in everyday life. You think he's and I say that with with love. You think they're going to put him on the stand? There's no way in hell they would ever put him on the stand ever. So I don't think that's ever going to happen. So him pleading the 5th, I don't think they would draw a negative inference against Karen because the 5th is something that you do to protect yourself. I mean, they can draw a negative inference against him, but if he doesn't say anything, it doesn't matter. Number 3, 2, 3, 4, 5, 6, and I don't think they're ever going to call him at all. I think it's a tactic to try and keep him out of the courtroom because Alberts and the McCabe's don't want him there. And probably the O'Keefes. Thank you, Cosmic Blue. It's like sweet and sour. Excited to watch, but afraid. Yeah. Yeah, well, here's the clock. The clock is up, so we got that going for us. We'll see what happens. I don't know how many are on the in the pool, as it were, today, and we will see. So, does anybody know anybody who is? Yes, Celeste never sleeps, Marissa J. That is true. Hank Brennan did do that in the Whitey Bulger trial. He put some reporters on the witness list so that they couldn't be in the courtroom. That kind of flew by, but I was going to highlight that, but except I saw it on my phone. Right, Turtle Boy had nothing to do with the murder. No, he didn't. Neither did Karen Reed. And yet, here we are again. Proctored Sally Port video again. Jay Pearl stating the obvious. TB wouldn't hold back. He'd let the Commonwealth know what he's thinking. Yep. Yeah, and they probably wouldn't like it. So why would they risk it, right? Why would they risk it? The trial, no, I don't. Gene, the trial's going back to the small courtroom. But today they're still in the big room because they're still picking, as it were. Oh, Gretchen Voss is in there. Oh, that John DePetro. Ugh. Well, let's see if he's even. Well, is Gretchen? It's like, which one would you pick to follow out of those 3? I'm gonna go to Gretchen Voss. Except, we'll see if she's live tweeting. No, the last time she tweeted anything was in September of 2024. So that's useless. Unless that's not really her, but it looks like it's really her. I don't know. It's got the link to Boston Magazine. News Nation. All right. Thank you very much, News Nation. I'll allow it. Let's see. Yeah, except do they have anything on their Twitter feed? No. That clock is the first clock in America. It's everybody else's clock that's off. Yeah, my clock says 9:26 and that one says 9:18. That's hilarious. It's like the old school clocks that would tick so loudly in school, and you'd just be waiting and waiting and waiting. Thanks, little cupcake. Good morning. Waiting and waiting and waiting for that clock to hit 2:45 to get the hell out of school. Yes, I just talked about Craig. I know we're very happy that he's there. We're very happy. Yeah, Gretchen Voss. Well, the trial has not started, so she can be in the courtroom right now. Last time they also made a motion to keep her out, or no, she was originally sequestered. Then they made a motion to let her in. Gretchen Voss. She's the reporter for Boston Magazine that did a couple of articles on Karen and with Karen, and she was allowed in. They did allow her to sit in Be sure to taste your words. This is a quote from LJ. Be sure to taste your words before you spit them out. My new response when someone speaks negatively to me. Yeah, there you go. I'll allow it. I like it. Here we go again. Grant. Yeah, Grant is in there. So Grant is he live tweeting? I don't know. I can't even with that guy. I got it. Hi, Kelly. I mean, I think I would rather stick a fork in my eye than read that guy's Twitter feed. So can we find anybody else? Anybody else? On the cesspool of Twitter. Oh my God. Oh my God. Okay, here's what that guy says, whose name shall not be named. Who is the son of Wendy Murphy. Oh, I gotta show you that. I gotta show you what Wendy Murphy tweeted. She's got a whole new theory. And if this turns out to be the Commonwealth's theory, it's gonna blow your mind. Did anybody see that? Grant says on Twitter, here's Monday. There's more paddy wagons than people. Here's Monday's moment where legacy media's Ted Daniel, Boston 25, shook hands with the glarer, a leader in the fleeting Free Karen Reid movement, which is down to about 15 people on the event of Reid's retrial. That's John O'Keefe's death. Ted Daniel then scurried away, and the three Reid fans had panic attacks while walking through the buffer zone and filming, despite orders not to do so, to get back in their cars. Like such a tattletale. Wah, wah, wah. Not sure if Ted Daniel has ever shaken hands with John's family or even offered to do so. I will look more into that and follow up on this important story as I am able to do so. Yeah, because that's the important story. That's the important story, you guys. Ted Daniel shaking hands with Will, the glarer. I mean, you can't even make this up because it's now it's at the point of just being embarrassing. Panic attacks. Yeah. Hi, Boozy. Panic attacks. Well, he's saying there's 15 people. Does he ever here's Tannis, Queen Tannis. Says, I'm her choice to watch this persecution. Well, thank you, Tannis. And, let's meet one day. Let's meet one day and go to court together, shall we? Tannis Yannetti is a queen. She is the sister of our king, David Yannetti. And she's an amazing, amazing, super cool human. Always happy to have her here. We're always so happy to have her here. Listen to this, because you have to hear this. Because this is his mother. This is the mother of Grant. And this is what she says. Because you can't even make this up. Well, you can make it up because they're making this up to spin it into the Twitter sphere. And this is her story, the step-by-step explanation of how Karen Reid killed John O'Keefe. Did anybody see this? And how many other people have tweeted? Was this the talking points of the week? Was it the talking points of the week for the witch hunters? The vampire hunters, the stone Karen Reid to death in Town Square before hanging her to death. Here's Wendy Murphy's step-by-step explanation of how Karen Reid killed John O'Keefe. So this, I would imagine, because, where does she get her information from? This is the new theory of the Commonwealth. I don't know for sure, but I'm going to say this is probably the new theory because if Wendy Murphy was given it, everyone else was probably given it too. Here she says, number one, Karen Reid and John O'Keefe each left the bar with a cocktail. Oh, so now they both left the bar with a cocktail. See how this is all spinning? They got into Karen Reid's car and drove to 34 Fairview, but Karen Reid didn't want to go to the party. They had a fight about it because John didn't want to ask his buddies to drive him home. Oh, really? Really? Does he know about Uber? I don't know. 2, when they pulled up, 34 Fairview was on the right passenger side. John O'Keefe got out with his cocktail in his right hand. He kept the door open and continued pressing her to come in. This is when a witness drove by and saw the interior light was on and only one person was in the car, driver's seat. J.O. was standing outside the passenger door, cajoling Karen to come in the house. There's no sound up yet in the courtroom, so don't worry. 3, when Karen Reid again refused to go in, John O'Keefe grabbed her cocktail from the center console with his left hand to pressure her even more because he knew she was a drunk and would want her cocktail. He now had a glass in each hand. Ooh, dun, dun, dun. What's going to happen next in this new version of the story? Hold on. Wait for it. Well, wait, where's the impact? Karen Reed persisted and in her refusal and began slowly driving away to taunt him, H-I-M, in big capital letters, just like they put on their new billboard. Remember him, and him is the biggest, most giant letters on that billboard. Doesn't say remember John O'Keefe. No, just remember him, like the guy. Tell them the guy never went in the house. There's a man passed out in the snow, and there's a guy unresponsive. Please hurry. Karen Reed persisted in her refusal and began slowly driving away to taunt him to get back in. As the back of her car passed where John O'Keefe was standing, he realized she was serious about leaving. So he kicked her taillight on the far right side where the red plastic was, and then threw her glass from his left hand at the back of her car, causing the small dent above the left side of the taillight. Number 5, taillight. It took Karen Reed a moment, 60 feet of driving, to realize what John O'Keefe had done. She became enraged that he not only took her drink, but also hit her car. So she floored it backwards, intending to scare or punish, not kill him. Oh, well, wait a second then. So now there's no intent to kill. Oh, this gets even better by the minute. John O'Keefe was bent over trying to get his shoe that fell off when he kicked her taillight. Wait, so that's how his shoe fell off? I thought his shoe fell off when he got hit by the car, because that's what Lally said last time. That's what happens, he said, in every single pedestrian accident. Now his shoe fell off from kicking her taillight. His back was to the house. He saw Karen Reed speeding toward him and put out his right hand to block her. He put up the back of his hand because he was still holding his cocktail, which is why the back of his hand was badly bruised at autopsy, right? Because he wouldn't let go of his cocktail because he was holding onto it for dear life. Is that what you're saying? Well, we know his blood alcohol content at autopsy, according to the vitreous sample, was 0.29. So that was even, a little bit, many hours after his death. Let's see, wait, where's the next? Because this goes on, it gets even better. Where is it? Here we go. The impact slammed John O'Keefe's hand with the glass still in it, into his face. Now, okay, now there's 2 glasses. Are you following me? One is in its face. One is in his face. The clock is still ticking. It's like in the courtroom, it's 9:27, but in real life, it's 9:35. So just putting that out there. Hence why Karen Reed pulled a shard of glass from John O'Keefe's face when she found him dead hours later. Well, that's really interesting, because if he was dead when she pulled the shard of glass out of his face, he wouldn't be actively bleeding. But no, we're going to ignore that fact. So moving on, or at least anyway, that's what Karen said in the documentary, which is where she's pulling this from. The already cracked taillight from John O'Keefe kicking it moments earlier. Okay, do you think a human kicking a taillight would break it? Anyone? Does anyone believe that? Does anyone believe that, like, even like the best jujitsu, karate, whoever is the hardest kicker in the world with the most force would be able to break a taillight on a Lexus? I don't think so. But anyway, let's keep going with this theory. The already cracked taillight from John O'Keefe kicking it moments earlier scraped John O'Keefe's arm through his sweatshirt as Karen Reed's car swiped him and spun him to the ground. There's the pirouette. Got to keep the pirouette. Where he slammed his head and passed out. We all know the rest. She left him to die. Wow. Excellent, excellent theory. I can't wait to hear if this is the one they're really going to use, because, who's leaking it? Number 7, this is why there are 2, quote, crime scenes. One where the taillight pieces were first broken because John O'Keefe kicked it in, and the other where more pieces broke off when she hit him. I'm sorry. Is that somewhere other than 34 Fairview? That's why there's 2 crime scenes. Can anybody point out to me why that makes 0 sense? 2 crime scenes. One where they were first broken because he kicked the taillight, kicked the door in. You can't even make this up, but they're going to try. Number 8, this is also why there were 2 different types of cocktail glass at the scene. Oh, there you go. Now you're explaining it. There were actually 4 different types of glass at the scene, but okay. One was his, one was hers. Got it. Karen Reed made a public statement declaring that she pulled a piece of glass from John O'Keefe's face when she, quote, found him, because she was worried the prosecutor found her DNA on a shard of glass at the scene. Well, that's a great Great. Excellent way to tie it all together. Good luck with that. This story is about an alcoholic, entitled, self-centered, wealthy white woman who was raised to believe she is better than the, quote, types of people who pay for their crimes. Well, I mean, well done to you. Only 2,900 views and 10 comments and 67 likes. She got ratioed, but does she care? No, I don't think so. But you know what? Her boy is in the courtroom today, so we'll see what we have to say about that. Yes, this was written by Wendy Murphy. She's an attorney. She played a role in disparaging the Duke lacrosse players. She's also Grant Smith Ellis's mother. So that's who wrote the fan fiction, Callista, and it's on the cesspool of Twitter. So if that does turn out to be Hank Brennan's new theory, won't it be interesting that Wendy Murphy has the theory? Has the other one whose name shall not be named on this channel, has she tweeted that theory yet? Yeah, a couple nuggets short of a Happy Meal, says Han. Libra in Seattle says, was it a pirouette? Or I don't know what that even says. Fouet? Inquiring minds want to know. Don't know a lot about ballet, but thank you, Libra in Seattle. Mad's Tea Party is here and gifted a membership. Thank you so much, sweetheart. Can the defense address the Commonwealth's new theory? Well, I mean, let's first see if they try and put that theory out there. I don't know if that's just a made up theory by a person on Twitter or if that's really going to be the theory from the Commonwealth. Because remember, so much stuff has been leaking to the press and to the people out there on Twitter, certain folks anyway, who seem to know a lot of things before the public knows. And I think they've been told to stop doing that. Don't do that anymore, says the judge. Fat, Dumb, and Happy became a member. Welcome, welcome, welcome. Everybody remember to hit the like button while you're here. See what the weather is in Dedham today. Is it cold? It's like 50 degrees here in New York. So let's do a weather check on Dedham. It is currently 52 degrees and sunny. It's going to be sunny all day long. I don't know. Do they have to turn the air conditioning on yet in this ancient courtroom? Remember, they just got Wi-Fi in this courtroom before Karen Reed's first persecution which was exactly a year ago. Exactly 1 year ago is when this court just got Wi-Fi. Can you believe it? Oh, thank you, Summer Fridays, says I'm her favorite law tuber. Thank you. Thank you. We're going to have Summer Fridays in this courtroom too. Don't you worry, because we have also, there's never really a full week in this courtroom. The judge tells the jury, and she'll tell them today again, the panel, that there will be full days every day, at least till 4, because that's when they go till 4. And unless I tell you ahead of time, we'll have a day off, because here's what we know from the last trial. There's like take off on Friday to get to the Cape. There's Taco Tuesdays, there's Thirsty Thursdays, and then there's like come in late Mondays, because traffic from the Cape, from what I hear, is it's crazy town in the summer, right? And so there's that. Hang on one second, I'm parched. Good morning. The Goodmans are here. The Goodmans are here. We love the Goodmans. And they've gifted a membership. And guess who won? Sharma Lily won. Oh, Sharma Lily, that's amazing. Sharma Lily's been hanging around for a long time, and now she's a member. So thanks to the Goodmans. Glamasuz is reminding us there were 30 days of trial, and it was 9 weeks. Yeah. Okay. So 9 times 5, last time I checked, is like 45. So there were only 30 days when there should have been 45. Were there any holidays in there? Yeah, I guess it was kind of like, there was like Memorial Day in there, right? It ended July 1st. So what other holidays would there have been? Cool. How does that? Oh, way. And I love when they have hot mics. We had some hot mic moments the other day in the Turk trial that were crazy. And then they figured out there was a hot mic and then they shut it off. No, not even ChatGPT can think of such rubbish, says Rachel. And she's right. Patriots Day. Are the courts closed on Patriots Day? That's like next Monday, right? From what I hear. But I don't know. Are the courts closed? Bunker Hill Day and Dorchester Day also? I don't know. I don't know if that's a thing. Usually courts are only closed on federal holidays. But okay, but still, again, Patriots Day is what? Like next Monday? Some people were thinking it was today, but it's not today. Yeah, they're late. They're late. And the clock in the courtroom is wrong because my clock says 9:43 and that clock says 9:35. So go figure. They need a clock winder. They need a clock winder to come in to Norfolk Superior. And whose picture is this? Anybody know? That was crazy in the Murdaugh trial. There was a picture in the courtroom where Alec Murdaugh was being tried that was like of his grandfather or great grandfather. And they had to take it down for his trial. That's how long the Murdaugh dynasty had been ruling the Low Country. I have no idea if she was in New Orleans. I don't know. I don't know. I have no idea. You know, sometimes a rumor spreads like wildfire, and I don't like to give it any air because I have no proof of that. But I have no idea if she was in New Orleans or what she was doing there, and I don't really care, really, to be honest with you. Your stock makes me smile. Free Karen Reed. Free Turtle Boy, says Cheryl. Thank you, Cheryl. LJ is my resident paramedic. She says, Officer John O'Keefe would have had a fractured foot if he kicked the taillight and broke it. No fracture, no kick, the end. Yeah, and especially if, like, didn't she say in her theory that the car was moving towards him and that's when he kicked it? Okay. Yeah, he also probably would have had a dislocated hip and some other things. Wait, let me just go back to her theory now. Not that I really want to even give it any legs. I just thought it was like hilarious. And if this is what they're really going to go with, you want to, I mean, why not just give them a whole bunch more reasonable doubt? This is why there were 2 crime scenes. It's just, I mean, you can't even make it up. Lisa has been here for 11 months. It's almost a year, Lisa. It's almost our anniversary. Suze has been here for 15 months. Isn't Karen considered a witness in the federal case? They started trial after Patriots Day. Memorial Day and Juneteenth were the 2 holidays. Got it. So Patriots Day changes every year. I guess it's not a set day. It's the day of the Boston Marathon. Is she considered a witness in the federal case? Well, she didn't testify. So I don't know what federal case you're talking about. Lisa, thanks for being here for 11 months. Debbie, thanks for your super sticker. Boiled Frog, did you catch Mass Accountability's video of a Canton cop schooling 2 Alberts on what a jury would consider stalking? I started watching it. I didn't finish it. But yeah, I guess they were making some sort of complaint against him for following them. And there's some interrogation video of it, but I have not had a chance to dig into it. Thank you for your super chat. Cheryl, I thank you. Helena, so both ballerina and a kicker, a round kick? Yeah. I mean, who knows? Who knows at this point? Lisa says, my dad's a retired lawyer. A retired lawyer. He's horrified. I mean, we're all horrified. Any lawyer who doesn't practice in Massachusetts is horrified. And those who do practice in Massachusetts are silently horrified because apparently it's, hard to speak out because, you have to practice there. So there's that. Oh, the trolls are also coming for Annie Elise today. Annie Elise 10 to Life said on her podcast that she was trying to get into the courtroom through Karen's family. And so now they're attacking her. Good luck with that. Good luck with that. What happened? They just turned the sound off. Why did they do that? It's back. Jury's entering, or somebody's entering. Judge is entering. God save the Commonwealth, everyone. We may have to modulate the sound, so let me know.
Jimmy, do you have those numbers for me?
Jimmy, do you have those numbers for me? Jimmy, you got the numbers?
You are unmuted.
Oh, and then he's whispering. Jimmy's whispering. Motion's in CPA. Thank you for your super chat. We use logic. Wendy does not. I'm surprised. Okay, there's Victoria George. Let's zoom in on her. She was the juror who was chosen as an alternate, who is now an attorney for the defense team. Motions in CPA says we use logic. Wendy does not. I'm not surprised she thinks this is a legitimate option for his death. Who gave her the talking points? That's what I want to know. Or did she just make it up all on her own? Thank you for your super chat. I think that's Victoria George. They have some interns working for the team or with the team from many of the law schools nearby. Some from Boston College, some from Northeastern, and some from maybe even Harvard. Alan Jackson is here. Bobby Scissorhands Alessi is here. I see Miss Theanetti. King David, I think he's wearing glasses right now, or Rita's. And there's Karen and Ms. Little. Clerk Jimmy 2 times. Clerk Jimmy 2 times. He needs the papers. Jimmy, get the papers. That's fantastic. That is Victoria. That's the president of the Harvard Law Review. Victoria George was the president of the Harvard Law Review. What? Or are you saying that person is? Or the person who's with her? Oh, I see. The student who's with her is the president of Harvard Law Review. Wow. You got to be real wicked smart to be on Law Review. All right. Yeah, we got to do this. Thank you. Thank you, Hurt Locker 66. Another 6,733 people in here. We all need to hit the like button. Put your DNA on that like button, folks. I promise that the Massachusetts State Police will not get a hold of your DNA. Lady McBev. Sadie. Melanie Chilling Bev is a vibe. No, she's Lady McBev. Or Kim Jong Kanone, whichever you prefer. I'll allow both.
All the jurors, please stand. Yea. All persons have any business before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court, in for the County of Norfolk. God hear, give your attendance, you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. Jurors may stand.
Judge,
Amen.
can I need you to raise your right hands, please? You solemnly swear to make true answers to such questions as should be put forth to you by the court, so help you God. Thank you. You can have a seat. May I call the case, Your Honor?
Please.
Your Honor, this is 2282CR117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record, starting with the Commonwealth?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
I'm Lyle for the Commonwealth.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms.
Good morning, Ms. Little.
Morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Yannetti for Karen Reed.
Good morning, Mr. Yannetti.
Good morning, Your Honor. Victoria George for Karen Reed.
Good morning, Ms. George. Good morning, Ms. Reed.
Karen,
Right,
say good
Jim.
morning.
Jim, we all set?
Jim, are we all set?
All right, thank you. All right, good morning, jurors. My name is Beverly Canoni. I'm a judge of this court, and I want to welcome you here today and give you some idea on how we think your day looks.
Oh,
As you've
you have
heard, this
no
is the matter
idea.
of Commonwealth versus Karen Reed. It's a criminal case. First, I want to thank you for your patience here with us today, and thank you for our service. One of the most important duties we have as citizens of this country is jury duty.
She said
And
duty.
we simply wouldn't be able to do this without you. So we do appreciate your patience here today. The Commonwealth alleges that at approximately 6 o'clock in the morning of January 29, 2022, the Canton Police Department received a 911 call reporting an unresponsive male party in the snow outside a residence at 34 Fairview Road in that town.
There's a man passed out in
Officers
the
responded
snow.
and discovered the man, later identified as John O'Keefe, off the roadway in the front lawn area. Officers identified 3 women with Mr. O'Keefe, one of whom was the defendant, Karen Reed, the girlfriend of Mr. O'Keefe. The defendant had been with Mr. O'Keefe the previous evening at 2 different bars in Canton and had driven with him to this residence in the early morning hours of this date. Mr. O'Keefe was treated by paramedics from the Canton Fire Department and transported to the Good Samaritan Medical Center, where he was later pronounced deceased. The Commonwealth alleges that the defendant struck Mr. O'Keefe with her vehicle earlier that morning and then left the scene while Mr. O'Keefe lay injured in the snow during a blizzard. The defendant denies these allegations. She is presumed to be innocent and has pled not guilty.
Really?
Ms. Reed is charged with second-degree murder. She is also charged with manslaughter while operating under the influence
She's
and
overcharged
leaving the
with
scene
second-degree
after
murder, you
causing
should say.
personal injury or death. I will describe these crimes in greater detail at the end of the case when I teach you the law, but briefly,
Every time she says, I'm going to teach you the law, I cringe and I get so angry. She instructs them on the law. Ask the judge sitting in the next courtroom. He knows how to say it. I will instruct you on the law, not teach you the law. We're not here to go to law school.
murder is the unlawful killing of a human being. There are various ways in which the Commonwealth can prove a murder case, and the Commonwealth is permitted to proceed under all theories that it believes it can prove. Here, the Commonwealth alleges that the defendant committed murder and that that murder was murder in the second degree. In order to prove the defendant guilty of murder in the second degree, the Commonwealth must prove beyond a reasonable doubt that the defendant committed an unlawful killing and that it was done with malice. In comparison, involuntary manslaughter is an unintentional, unlawful killing caused by wanton or reckless conduct.
Except John
These
O'Keefe was
terms-
not hit by a car. John O'Keefe was not hit by a car, and a car did not hit John O'Keefe. What are we doing here?
And the elements of the crimes will be explained to you in detail at the end of the case before you begin your deliberations. Now, at the outset, I would like to address the issue of public opinion and interest in this case and the duty of this court to adhere to the rule of law. John Adams said that we are a government of laws, not of men,
John Adams.
and that the law must be deaf to the clamoring of the public.
The law is deaf,
He
all
meant
right.
that while public opinion about a given subject may ebb and flow, the law must be steady, reliable, and even-handed. We know that on the subject of this case, there are people advocating for one outcome or another with intensity, but without the benefit of having heard or seen any evidence at all in this trial. The law works in a different way, and the difference is crucial to our system of justice.
She's going to let the sirens
jurors
go by.
selected for this trial will hear and judge the evidence. They will decide what the facts are, and where the evidence is contested, they will determine where the truth lies. Ultimately, the jury will decide whether the Commonwealth has carried its burden of proving that the defendant is guilty of any crime beyond a reasonable doubt. People outside of this building have rights, and we know that they have
Really?
voices.
No,
But
they
this
don't.
criminal trial will be decided by an independent jury, free from outside
Except for
interference,
First Amendment, they don't
based
have the right to freedom of speech. There's no First Amendment rights, but other than that, the people outside have rights. Oh, other than the right to be wrongfully persecuted for violating certain statutes that the Massachusetts State Police only want to enforce against certain people who think Karen Reed did not hit John O'Keefe with her car. Got it.
only upon the evidence presented in this courtroom and the law. This is the only way to ensure that every person who comes before the court receives a fair trial. It is just that simple and that important. So, while public comment will likely continue, the rule of law will be upheld. In order to determine your eligibility to serve on this case, I'm going to ask you questions all as a group, and then I'm going to ask you to fill out a supplementary questionnaire. We have found that the use of this questionnaire is helpful for several reasons. First, there are some personal questions on it, and we ask that you be candid. In addition, the process of filling out the questionnaire provides the opportunity to be more reflective as you answer the questions, rather than being put on the spot and asked to give an immediate answer. After you fill out the questionnaires, we will have you come up to the sidebar one at a time so that we can follow up with you on your answers to the questionnaire and your answers to my questions. I want to thank you in advance for your patience as we go through this process.
I turned my volume down.
As you may
When I
know, the
saw that.
lawyers for the parties participate in the selection of the jury. Under our law, each of the parties has the right to exercise what we call juror challenges. This means that each party has the right to challenge a certain number of prospective jurors for any reason or for no reason at all. Therefore, some of you will be excused during the impanelment procedure. Please do not take it personally. Don't think that somehow you're not a fair person. It's not a reflection on you at all. You will be directed back to the jury room and may be picked for another case. In a little while, I'll pose a number of questions to you as a group. You've taken an oath that requires you to truthfully answer these questions and all questions posed to you. I'm not asking you to take out your juror cards now. I'll ask you to do that at a later time. But if your answer to any question is yes, I will ask that you raise your hand and hold up your juror card in the air with the numbers facing out so that the court officers can read out your number. The fact that you answer yes to any of my questions does not mean that you're automatically disqualified from juror service. It simply means that there are matters that the lawyers and I need to discuss with you. If you find a question posed to the group to be overly intrusive, you may elect to answer that question at sidebar as well. I will have additional questions for you which relate to issues that may be raised in the trial and are designed to give us information regarding whether or not you're able to serve as a fair and impartial juror in this case. The lawyers are allowed to ask you questions for the same reason. There is no right or wrong answer. This is not a test. We are simply looking for your best and honest answer to our questions. I'm now going to have the lawyers introduce themselves, please. And when defense counsel introduce yourself, please introduce your client. So let's start with the Commonwealth, please.
Remember, you never get a second chance to make a first impression. If you were sitting in this panel, what kind of impression would these attorneys make on you? Think about that.
May I?
Yes.
Thank you, Your Honor. Good morning, ladies and gentlemen. My name is Hank Brennan. I represent the Commonwealth of Massachusetts. I'd like you to meet my two colleagues.
Good morning, my name is Laura McLaughlin. I'm Assistant District Attorney in Norfolk County, representing the communities in Norfolk County. Thank you very much for being here this morning.
Good morning, my name is Adam Lally, Assistant District Attorney with the Norfolk County District Attorney's Office. I just want to thank you for your time and attention.
Did you see how he
Thank you.
pointed at them with his thumbs?
Mr.
I'd like to
Jackson?
introduce my co-counsel.
Alan Jackson. I have the honor and privilege of representing Ms. Karen Reed, who's standing to my right.
Good morning, ladies and gentlemen. My name is Elizabeth Little, and I also have the honor of representing Ms. Reed.
Good morning. My name is Robert Alessi. Thank you for being here and taking the time. I have the pleasure of representing Ms. Reed as well.
Good morning, ladies and gentlemen. My name is David Yannetti. I'm an attorney. I have an office in Boston and right here in Dedham. It's truly my privilege to represent County.
Good morning, everyone. My name is Victoria George, and I also have the privilege of representing Ms. Reed. Good morning, I'm Karen Reed. Thank you for being here.
All right, thank you.
All right.
Jurors, I'm
You're
going to read you a
all
witness list.
set.
It's very long. It does not mean that all of these people whose names I read to you will be called as witnesses, but you may hear their names throughout the trial. So please listen carefully because in a few minutes I'm going to ask you whether you know any of these folks. So it is alphabetical, but it's alphabetical by first name.
If you haven't heard this before and you happen to be an organized person or someone with OCD or in any way, shape, or form a professional, what you hear next with regard to the alphabetization of this witness list may trigger you. So consider this your trigger warning.
Aidan Kearney from Jefferson, Mass. Dr. Isaac Wolf from South Miami, Florida. Alfredo Lopalato from Canton. Allison McCabe, Canton. Andre Porto, Massachusetts State Police Crime Lab. Andrew Klain, Bridgewater. Andrew Rentschler, PhD from Pittsburgh, Pennsylvania. Angela Malvone, Annie Chung, both from Canton. Anthony Flamati from the Canton Fire Department. Ashley Bell, Canton. Ashley Valier from the State Police Crime Lab. Brian Albert, Norwood. Brian Albert Jr., Boston. Brian Higgins, Sandwich. Brian Loughran, Canton. Brian Wanless, who is a retired from the Canton Police Department. Bridget Meehan, who is keeper of the records in Canton. Caitlin Albert, Easton. Lieutenant Charles Ray of the Canton Police Department. Chief Helena Rafferty, also of the Canton Police Department. Chris Van E., who is a PhD from Novi, Michigan. Christina Hanley from the Massachusetts State Police. Christopher Albert, Canton. Christopher Curran, Canton. Colleen Crawford from the Norfolk County DA's office.
Oh, I can't wait for her cross.
Colin Albert, Canton. Courtney Proctor, Canton. Kurt Roberts, Canton. Daniel Whitley from the Canton Fire Department. Daniel Wolf, PhD from
Crash
Penns Park,
Daddy.
Pennsylvania. Derek Ellington from Wake Forest, North Carolina. Dr. Marie Russell, who's from Los Angeles. Dr. Elizabeth Loposada, who is from Providence. Elizabeth Proctor, Canton. Eric Hanlon, Canton. Erin Beatty, Canton. Erin O'Keefe from West Bridgewater. Francis Walsh from the Canton Fire Department. Garrett Wing from
Woot
Green
woot.
Cove Springs, Florida. Gary Fowler from Brockton. Gregory Woodbury from the Canton Fire Department. Gretchen Voss, Boston. Hannah Knowles from the State Police Crime Lab. Heather Maxon from Walpole. Erabito Hernandez from the Boston Police Department.
Sucker
Holly
punched by Brian
Price
Albert.
from Mountain View, California. Ian Whiffen, Vienna, Virginia. Dr. Irene Scorti Bello, who is with the Office of the Chief Medical Examiner in Massachusetts. PhD James Crosby from Jacksonville, Florida. Janet Reed, Dighton. Jason Becker, Canton Fire Department. Jean DeMoulis, Canton. Jennifer McCabe, Canton. Jessica Hyde from Bridgeport, New York. John O'Keefe Sr., who lives in Braintree. Judson Welcher, also a PhD from a company called Aperture LLC. Julie Albert, Canton. Julie Nagel, Canton. Dr. Justin Rice from South Weymouth. There are 2 juveniles in this case, both of whom live in Canton. The first
that's
one's initials
necessary.
are KF.
Let's bring
and
the
the
kids
other
back
is
in, traumatize them
PF.
some more for no reason.
Caitlin Boudreau, Raynham. Karina Kolakithis from Canton. Katie Camerano, Canton. Katie McLaughlin, Canton Fire Department. The keeper of the records for Ring from Hawthorne, California. Kerry Curran from Canton. Kerry Roberts, Canton. Kevin Albert, Canton. Kevin O'Hara from the Mass State Police. Lance Mello from the State Police Crime Lab. Laura Sullivan from Pembroke. Laurie Cahill from Worcester. Leslie Pearlstein from Canton. Lieutenant Michael Lank from the Canton Police Department.
Lanka.
Louis Jutras, Canton. Lieutenant Brian Tully and Lieutenant John Fanning, both of whom work for the Massachusetts State Police. Lieutenant Paul Gallagher from the Canton Police Department. Maggie Gaffney, Bonita Springs, Florida. Mark Lopalato, Canton. Margaret O'Keefe, Canton. Marietta Sullivan, Pembroke. Mary Souza, Dighton. Matthew Amory from Canton. Matthew DeSogra from Charlotte, North Carolina. Matthew Erickson from Grosse Pointe Farms, Michigan. Matthew Kelly from the Canton Fire Department. Matthew Kelsch from the FBI. Matthew McCabe, Canton. Maureen Harnett from the Mass State Police Crime Lab. Megan Mariani from New York, New York. Michael Camerano from Canton. Michael Easter, Los Angeles. Michael Trotta from the Canton Public Works Department. Michael Wagner, Foxborough. Mike Moroli, Bridgewater. Mike Rushworth from Thompson Station, Tennessee. Natalie Wyweek Berschneider from San Marino,
Natalie the
California.
German.
Nathan Reed from Raynham. Nicholas Bradford from Lorton, Virginia. Nicholas Curran from West Roxbury. Nicholas Kolakithis, Canton. Nicole Albert from Norwood. Norfolk District Attorney Michael Morrissey. Officer Kelly Deaver from the Boston Police Department. Officer Nicholas Barrows from the Dighton Police Department. Matthew Haggerty from Somerset. Paul Mikowski from Melrose. Paul O'Keefe from Canton. Rebecca Bison from Canton. Rebecca Trayers from Norfolk. Dr. Renee Stonebridge, who is also with the Office of the Chief Medical Examiner here in Massachusetts, and she works out of Boston.
She said Patthew. Did she say
Richard
Patthew
Green from-
Haggerty? It's Patrick Haggerty. I thought she said Patthew.
the St. Pete Beach, Florida. Richard Donatno from Canton. Robert Gilman from Hull. Ryan Nagel from Canton. Sarah Levinson, Canton. Sergeant Brian Gallerini from the Needham Police Department. Sergeant Sean Good from the Canton Police Department. Sergeant Paul DiGiampetro, who Canton Police Department. Sergeant Yuri Buchanan from the Mass State Police.
That'll be good.
Shannon Burgess from South Lake, Texas, Cheryl Waugh from Canton, Sophie Herzan from the State Police Crime Lab, Stephanie Devlin, also from the Crime Lab, Stephen Mullaney from the Canton Police Department, Steve Nelson from the Norfolk DA's office, Stephen Bernstein, who's a keeper of the records from Stoughton, Stephen Ridge from the Boston Police, Stephen Seraph from the Canton Police, Stephen Scanlon from West Roxbury, Terry Kuhn from Davis, California, Tess Chart from Lorton, Virginia, Thomas Beatty from Canton, Thomas Kelleher, Canton, Thomas Martin from Weymouth, Timothy Nuttall from the Canton Fire Department, Tristan Morris from Easton. The following people are Mass State Police troopers: Trooper Connor Keefe, Trooper David DeChico, Trooper Evan Brent, Trooper Jeffrey Koskowski, Trooper Joseph Paul, Trooper Kathleen Prince, Trooper Michael Proctor, Trooper Nicholas Garino, Trooper Zachary Clark. Wendell Robery from Canton, and William Reed from North Dayton, Mass. So those are potential witnesses in this case, or people whose names you'll hear during the trial. Obviously, this trial is going to take a long time to try. The lawyers tell me that their best estimate, once we start with the evidence, is 6 to 8 weeks. We are in the process of impaneling a jury. We don't know when we'll finish that. We're toward the tail end of finishing that. But once we start, it will be a 6 to 8 week trial. That's our best estimate. Sometimes trials go longer, sometimes they go shorter. I can tell you that every day before we leave for the day, I tell jurors where we are, if we're on schedule, behind schedule, or ahead of schedule. And I've not had to tell a jury that we were behind schedule, and that's why we have that 6 to 8 week estimate. The schedule that we will have is we will start in the mornings at 9. We'll go until about 11 or so and have a break for about 15 or 20 minutes. We'll break for lunch, and you will have lunch delivered to you so that we don't have you walking into town center and coming back, because we want to make the most efficient use of your time. So we'll do that, and our lunch breaks will be shorter because of that. And we'll go until about 4 o'clock every day. So that's the schedule. There are some days off and some half days in that 6 to 8 week period. And if you're selected for a jury, you'll get those dates before we start. So that's our schedule and the best estimate of where we'll be. Now, it might help if I give you a preview about some of the basic law that applies to criminal cases like this. As I said, it's my job to teach the jury the law, but I don't do that completely to the end of the case. But for now, I'll give you a brief summary of some of the very legal, constitutional principles that will govern this trial. First, and most basically, the defendant starts this trial presumed to be innocent. The fact that she was arrested or that she was indicted is not proof of anything. An indictment is simply a piece of paper. It just makes an accusation. An indictment is a formal manner of accusing a person of a crime and bringing that person to court to stand trial in the Superior Court. But it is only the jury, in other words, you folks, who can decide whether the prosecution has proved its case beyond a reasonable doubt. If the Commonwealth fails to do that, then the presumption of innocence requires you to find the defendant not guilty. The law does not require a defendant to prove her innocence, to produce any evidence whatsoever, or to do anything other than attend the trial. This presumption of innocence remains with the defendant until you, the jury, make your determination after listening and considering all the evidence. In a related important principle of law, the defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that she is guilty. Under our system of law, a defendant has a perfect right to say to the government, "You accuse me, now you prove it, and prove it beyond a reasonable doubt and to a moral certainty. I do not have to say a word."
You accuse me, you prove it. Has she been saying this every day? Because how did I miss that bit of comedy gold? You accuse me, you prove it. I don't remember that. It just keeps getting better and better. Hold on, I gotta hear that again. Hold on. How did I miss it?
Say to the government, You accuse me, now you prove it, and prove it beyond a reasonable doubt and to a moral certainty. I do not have to say a
Maybe she just said it with a little more feeling today, a little more gusto. She's had a well-rested weekend.
word. A defendant's decision whether or not to testify has nothing to do with the question of whether he or she is guilty or not guilty. The jury must not consider it in any way or even discuss it in their deliberations. Jurors in a criminal case must decide.
Hold the phone. She could wait because look who's here, you guys. Rubia is here. Rubia is here. Did you guys watch my show on Saturday night with Nurse Kim? And we played Rubia, who's a medical malpractice defense attorney who told us everything that we need to know about Dr. Stonebridge. That's awesome. Insta messages get lost in a black hole, Rubia, but I'm going to go find it. So I'd love to talk to you. Rubia is here. She found me. Yay. Thank you. Thank you so much for your super chat as well.
Whether the Commonwealth has proved its case against the defendant beyond a reasonable doubt based solely on the testimony of the witnesses and the exhibits. That brings me to the requirement of proof beyond a reasonable doubt. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in a case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough.
What about a 0 probability that John O'Keefe was hit by a car? What about that? What about 0? Shouldn't they dismiss the charges outright, or shouldn't you have dismissed this case based on the Brady bunch of violations that was obviously shown to you, but you didn't even want to have a freaking hearing on it? Possible jury tampering. No big whoop. Let's just keep going because we have such morality in this court. We're full of morals here.
Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve a fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability,
Unless the
gender,
troopers want to pin it
sexual
on the girl,
orientation,
then I'll allow it.
education, income level, or any other personal characteristic. You have agreed to be fair, and I'm sure that you want to be fair, but that is not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we're not aware of them and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that is what I'm talking about. Of course, we judges have the same problem as everyone else, so let me share a few strategies that we have found useful. First, slow down.
People
Do
like
not
the pink
rush
font.
to a decision.
Sorry, you don't like it.
Hasty decisions are more likely to reflect stereotypes or hidden biases. Second, keep an open mind. Avoid drawing conclusions until the end of the case when you and your fellow jurors deliberate. Remember that when you deliberate, you will have all the evidence and all the time you need to make a careful decision. So there truly is no need to start making your mind up before then. Third, you should listen closely to all the witnesses. That is the best way to ensure that you decide this case based on the evidence and the law instead of upon any unsupported assumptions. Fourth, as you listen to testimony about the people involved in this case, consider them as individuals rather than as members of a particular group. Finally, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? At the end of this case, I will remind you of these strategies and ask you to focus on the evidence instead of on any unsupported assumptions you may have. All we ask is that you, individually and as a group, do your best to resolve this case based upon the evidence and the law, without sympathy, bias, or prejudice, to the best of your ability as human beings. Now, I know
Never.
that some of this may be confusing. Perhaps all of it is confusing at this early stage of the case.
Yes, we're
You'll
very
certainly
confused
be in
about
a
what we're
better
exactly
position to
doing here,
understand
Your
this
Honor.
at the end of the case, when you've heard the evidence and I can explain the law in detail. So don't be worried if you didn't catch everything that I've said. Why am I telling you these things now? Because we need to know if you're able to follow the law in this case. You don't necessarily have to agree with the law, but all the jurors will have to apply the law as I describe it. So, for jury selection, it is important to know if any of you might have some doubts whether you can accept and follow these legal principles. So you can take your white cards out now if you don't already have them. So I'm going to
Here
ask
we
you
go. They're gonna have to
several
raise their
questions, and
cards.
if your answer is yes to any of those questions, please raise your hand. But before we begin,
She's very chipper
I
today.
understand that sometimes we don't fill out the confidential juror questionnaire forms that were sent to you completely. Sometimes we're in a hurry to get them in, or sometimes you might think that your situation doesn't apply to the question that's been asked. So if you're sitting here now and you realize that maybe you forgot to put in your age or prior employment, or whether or not you've had experience as a defendant in a criminal case, or a party in a civil case or criminal case, or as a witness or a juror, please let us know when you come up to sidebar. And if there's a blank that needs to be filled in and you didn't remember it and we catch it, we're going to ask you those questions.
It's always
All right,
something, Santiago,
so-
you know.
First question. Do any of you folks or a close personal friend or family member know, or have you had any prior dealings with any of the witnesses whose names I've read?
963, 987, 1013, 982, 1034.
Stop zooming in on her privileged conversations with her attorney, cameraman, or they're going to kick the cameras out of the courtroom.
1038, 994.
Okay.
It's not like
Thank
7
you.
people?
Do any of you folks or a close personal friend or family member know, or have you had any prior dealings with the lawyers or the Norfolk County District Attorney's Office? If so, please raise your hand.
982.
Thank you.
Only one?
Do any of
How many
you
people
or
are
a
there?
close
We don't even
personal
know.
friend or family member have any financial or other personal interest whatsoever in this case or its outcome? I see no affirmative responses.
Nobody.
If you have seen, heard, or talked about this case, please raise your hand.
Oh, Christina Rex is in the courtroom. Thank you. Thanks for telling me. Thanks, Dorothy.
989, 995, 988, 1030,
There are 55 people in the panel today.
960, 1000,
Yeah, why don't they ask if anybody knew John O'Keefe? That's a great point, Loudmouse. Of course they should ask that.
1039.
Yeah, great idea. Let's focus on the empty chairs, cameraman. Wonderful, or camera woman, camera person. Great. Excellent work. Bravo.
965. 1027. 1021. 1015. 992. 1031.
No, Jim, it's not time to draw the bingo numbers yet.
998. 986.
Uh-oh. It's not Nancy. New court reporter alert.
1037.
Nancy was busy on the Turk trial, so
1038.
it doesn't look like she's going to be on the Karen Reed
Okay,
trial,
thank
but I
you
guess
very
we'll see.
much. Please raise your hand if you have expressed or formed any opinion with respect to this case.
All of them. Can't make it.
1035, 1011, 978, 967, 987, 964, 972, 10, 993, 976, 10, 36, 179, 1005, 988, 983, 968, 960,
1028. 1027. 1015. 992. 1031. 970. 998.
All right, thank you.
Like half the people, like 50% have formed an opinion on the case. A little less than
Are
50%.
any
There's
of you folks aware
55
of any
people there. So.
bias or prejudice that you may have in regard to this case or in favor of or against either of the parties? If so, please raise your hand.
That's the quickest way to get thrown off.
1032, 987, 978, 993.
Only 4 out of 55.
Thank you. Do any of you folks have any difficulty hearing or any problem with
What?
understanding the English language? Any physical or mental condition or any religious or philosophical belief that would make it difficult for you to hear the evidence in this case, to understand the evidence, to concentrate during the trial,
Smooth as
or
butter.
to
Alan
deliberate for the
Jackson.
purpose of reaching a verdict? If so, please raise
Leave
your
an
hand.
emoji for that.
I see no affirmative responses.
I'm sorry, just one after the.
Oh, it's 2.
1032, 966.
Okay, thank you. Would any of you folks have any difficulty following those very important constitutional rights that I explained to you? First, that the burden of proof rests entirely with the Commonwealth.
But it's a nice
Second,
thought.
that burden of proof is proof beyond a reasonable doubt and to a moral certainty. And third, that the defendant has absolutely no burden. She can just sit in that chair and not ask a single question, not produce a single witness, and not testify on her own behalf. Anyone have any difficulty with those 3 very important constitutional principles?
Yes. Do you believe in physics? That should be a question for sure, Emily.
Now, I can tell you folks that after every jury trial, I talk to the jurors, and they always tell me that even though they may have not wanted to have jury duty, that they have found it to be an interesting experience, and many tell me that they find it to have been a rewarding experience. But I do understand that for some of you,
Rewarding unless you know, we, the jury, agreed to acquit on a couple of charges and you didn't want to hear us. In that case, it was like the opposite of rewarding. It was the most horrific post-traumatic uh, experience that they've ever had in their lives because nobody listened to them. So yeah, it's rewarding unless that happens where we acquit someone and then you don't ask us. And now the U.S. Supreme Court is going to decide whether or not they're going to hear the issue on double jeopardy, which, you know, in the United States of as such, America is a constitutional right for most people who live in the United States of America, but you know, not so much in this courtroom. So it's not really that rewarding. And I have questions about whether you even really spoke to the last jury in the persecution, Karen Reed, but I digress.
Few jurors, given the schedule that we have, serving on this jury may be a substantial hardship. And let me tell you what I mean by substantial hardship. Every civic duty that we have requires us to be inconvenienced in some way. This is much more than inconvenience. It
And
means
who else
that
is
there's something
inconvenienced?
personal to
That
you
woman right there
that
sitting at the
means
defense
that you
table.
will be
Karen Reed, she's
excused, but the person
inconvenienced.
sitting next to you will have to take your place. I generally think of it in terms of you have surgery or vacation plans scheduled,
That's it.
airline tickets scheduled for the time that we will be in jury trial here. If you think you have a substantial hardship, please raise your hand.
990, 1035, 1011, 978, 967, 964, 972.
It was so rewarding, that experience, that it led a juror to join the defense team because she was so outraged. Listening to Brendan to the personal hardship, I'll allow it, Little Misfit. Yep. Right. Gray space. Ms. George sitting there like, I'll show you a rewarding experience. She was pregnant with twins when she sat on a juror as a juror in this case. She was pregnant with twins.
973, 988, 1022, 1018.
A lot of surgeries in Massachusetts. Yeah.
1027.
Good, Bethany. Well done. Everybody's on vacation. They're like, yeah, I have plane tickets.
1031, 970, 1038.
That's a lot.
Okay.
That's
Thank
a
you
lot.
very much. So I'm going to leave the bench in a minute or so to give you a chance to fill out the juror questionnaires. I'd ask that you not talk to anybody about the questionnaires, either about what your questions might be or comments or any concerns that you have about jury duty, either generally or in particularly this case. And please don't share your answers. So if you have any questions or concerns, you'll be able to talk to me about that when you come up to sidebar. All right. Thank you very much.
You're all set, jurors. You're all set, potential jurors. You're all set until I decide to just tell you that you can leave because you might be friendly. That's all we're going to get today. And there's the bars. Ooh, hot mic.
You are muted.
You are Free Billy Tibbetts.
Goodbye.
Free my boy Billy Tibbetts. Free my boy Billy Tibbetts. If you know, you know. Remember Free Billy Tibbetts during that Zoom, during the first persecution? Free Billy Tibbetts was like during a pretrial hearing, and they didn't know how to mute the Zoom people on Zoom, and somebody on the Zoom kept saying, "Free Billy Tibbetts, free my boy Billy Tibbetts." All right, according to Christina Rex, who is a reporter with WBZ in Boston, I'm going to readjust my volume now, so you can readjust your volume now before I blow out your ears. Hang on a second. Testing 1 2, testing 1 2. Okay, according to Christina Rex of WBZ, who remember she was the first one to get the hot interview with Paul O'Keefe after the first trial. Christina Rex says 89% know of the case today. This has been the average percentage for this second trial. She says of 55 potential jurors on day 9 of jury selection in Karen Reed's retrial, seen, heard, or talked about the case 49 out of 55. 24 out of 55 have formed an opinion on the case. 4 of 55 have a bias or a favor for a particular party. Substantial scheduling and hardship issues like plane tickets or surgery, 28 out of 55. As we know, or maybe you don't know, but I will tell you, they have 16 jurors already selected, 8 men, 8 women. So that is 12 plus 4. I think they're trying to get another 2 today. As far as I know, they're supposed to open tomorrow. There's been some rumors that they may not open until Wednesday until I hear it from some sort of source who knows for sure. I can't really say much about that. She says, we, the media, have not received an update regarding whether any jurors have been lost. I will update you if that changes. That's Christina Rex. I consider her to be a reliable source. And she says, I don't believe the jurors get called daily, but I do know they're kept updated about when they might need to come back for opening statements, meaning I guess they don't call them every day to tell them what the situation is. Hold on a second. And so it has been said that they're looking for 2 more. The goal is 18. There's 15 there. And so the judge had originally said they're going to open tomorrow. I have not heard anything yet to the contrary, and I do not know if there's anything in my inbox regarding. So let's take a look. Nothing yet. Thank you, Lori, for your Venmo. Who says, I wish they would go with the fakakta theory. Good Lord. Thank you. No, you're the best, Lori. You're the best. You are the best. And thank you so much to Kathleen. Oops. This is just because you're classy. Oh, you're sweet. Well, let's see. Is there anything that has dropped today yet? And I'm sure that some things will drop later. So the thing that you're going to want to do, you're going to want to make sure you hit the subscribe button because it's free. You're going to want to make sure your notifications are set to all, because when motions drop or decisions drop, I just go live and do them, and you won't get a notification unless you have them set to all. So you're going to want to do that. And also you're going to want to make sure that notifications are enabled on your phone, because if they're not enabled on your phone, you're not going to get the notifications. Let's see if we have any. I did. I was at the Sphere one weekend, actually, Funk, with Andrea Burkhart and her husband, and we had an awesome time a couple of weeks ago. I think it was the second weekend of this round of Dead shows. So yeah, it was awesome. We were there for the weekend and we had a great time, and we got to meet each other in person, and it was awesome. Kat says everyone knows something about this case. They're lying if they didn't raise their hand to that question. It was on the news in Southern California and even in Vegas last year. Yeah, it's everywhere. Everyone knows about it. Everyone knows about it. And Monj says, good morning. Awesome to spend my Monday with you. Thanks for being with me for 5 months, and thanks for joining. Patty McDaniel, thank you for thanking me. Tammy says, I was so excited about the 10% off last week that I ended up with a hoodie and a zip-up sweatshirt to come in today. That's awesome, just in time. So excited. Thank you for your kind read. Thank you, Tammy. Nothing to see here. If Crawford or Morrissey are not called by the Commonwealth, can the defense call them? Have they decided on the lawsuit for the 3 residents? I don't know. I don't know what's happened with that lawsuit for the 3 residents in federal court, to be honest. I think it may have been denied, but I haven't seen the decision, and so I don't want to give you the wrong info on that. They can call them. She said they can call them to the stand, Morrissey Morrissey they can call, and the witness advocate, but they need to make a proffer or do an offer of proof before they're allowed to testify. And Crawford, they can absolutely call, but Crawford is on the Commonwealth witness list, so I think they are going to call her because she's like the video person that is employed by the Norfolk DA's office, and she's got a history. Spock's Brainworms, thanks for your 5. A judge who cares more about her precious schedule than justice makes me sick. Well, I think you're in good company, and Rubia has found me. Praise be, under her eye. That's the other thing we say about Judge Cannoni, under her eye, because it's like being in a Handmaid's Tale-esque situation. Rubia, send me a message on Insta. I'm going to find her, because the universe works in mysterious ways. Thank you so much for your 20. Darlene says, can we hire Rubia for Karen's team, please? Well, I'm not in charge of hiring anybody, and I don't know that we have the ability to hire anybody for anything. But, maybe too late at this time, at this point, because, trial's starting like tomorrow, maybe, or Wednesday. I don't know anything about that. Cal, I don't know if I'm not going to disparage the judge. And no, V, I know V. I don't know what that means. Train station number 6. I don't know what you're talking about. But thank you, Miners Cal, for your super chat. Teresa says, thank you for code. No, thank you. No, thank you. Sky is a neighborhood. Serious question. What is Lally's role this time around? Well, I heard it looks like he has been. Oh, thank you, Mass Dad, for sending me the federal lawsuit decision so we can take a look at it, which we will do right after this. Serious question. What is Lally's role? So here's the thing. It looks like he's just been sitting there like, Gru from Despicable Me with his humpback and his book bag, and he's been the water boy. But people who have been in the courtroom this time around say that he's got it seems like perhaps he has a pretty big role. And so I guess it's going to remain to be seen. Oh, this is 11 pages long. Oops. All right. Let me know if you want me to read this federal decision. It's 11 pages long. And it is regarding the temporary restraining order that was filed on behalf of a couple of residents with regard to the buffer zone. And that was just actually issued on, it looks like, Friday. Yes. Okay. All right. I'll get my voice ready. And so we don't really know what Lally's role is going to be. Is Brennan going to question all these witnesses just like Lally did? I don't know. It remains to be seen. Sinbad loves the cupcakes. Thanks for being here for 9 months. Little Misfit. Yes, please, Andy Bev. How would you react to this case if other witnesses were involved? Seriously. Thank you for your super chat. I got to teach you rubes the law, then toss your verdict, says Track Worker. Kind of did happen, right? Send you an email how ARCA can medically prove Karen did not hit him with her car. Okay. Well, I don't have any access to them, so I will read that for my own information. Thank you. Bev may talk to the jurors, but she does not listen to them. It's a one-way street, not a two-way conversation. Thank you, LJ, for your 2 super chats in a row. Next week is school vacation here in Massachusetts, says Kay Willis, the realtor. Oh, so a lot of people are going away. Is that what you're thinking? Thanks, Kay. Bobby Alessi's Slice and Dice, now open for business. Vacation plans? Just take the red eye, Mr. Jackson. Nothing to see here. Thank you. And nothing to see here says, does Bev ask the jurors if they can understand the basics of laws? The defense asked her to give clearer instructions to the jurors, and Bev says, nope. We have an emoji for that too. Nope. We have a nope emoji. We have so many emojis for this trial that we're going to get to use all over again. The puffy jacket, the solo cup, the leaf blower, the handcuffs, the twilight. We are outraged. Wait for us. All of it. All right, let's take a look at the federal decision regarding the buffer zone, because we did look at the lawsuit, and now we're going to take a look at the decision that was filed on Friday. And then while we're here, what usually happens is more decisions drop, and then we just cover them as they come in because, I'm here for you. I'm here for you. Right. This is in the federal court, the U.S. District Court for the District of Massachusetts. And remember, these are the plaintiffs represented by Mark Randazza, who is a First Amendment lawyer. That is what he does. That is his specialty. And he filed a lawsuit with regard to the buffer zone saying that it's unconstitutional because you cannot legislate the First Amendment in private businesses and such things as like that. Give me 1 second. Talk amongst yourselves for a second. Thank you. And here is the decision. It is the memorandum in order on plaintiff's motion for temporary restraining order dated April 11th, 2025. On April 1st, 2025, wait, let me just make sure that I like my red pen, and I don't know, will it highlight? Sometimes it does. Oh, it does. Look at that. Okay. On April 1st of 2025, 4 Massachusetts residents, Jason Grant, Allison Taggart, Lisa Peterson, and Samantha Lyons, collectively the plaintiffs, filed suit against defendants, Trial Court of the Commonwealth of Massachusetts, Beverly J. Cannoni, in her official capacity as Justice of the Superior Court. Jeffrey Noble, as Superintendent of the Massachusetts State Police, Michael D'Entremont, in his official capacity as chief of the police department of the town of Dedham, Massachusetts, and Michael W. Morrissey, in his official capacity as the Norfolk County District Attorney, collectively defendants. Plaintiffs allege that Judge Cannoni issued a buffer zone order imposing unconstitutional prior restraint and infringing on their First Amendment due process rights. Plaintiffs filed a motion for a temporary restraining order, seeking enjoinment of Judge Cannoni's March 25th, 2025 order. A hearing was held on April 4th, 2025 at 2:30 p.m. The parties completed briefing on April 10th, 2025. Upon consideration of the parties' briefs and supporting evidence, the parties' oral argument, and for the reasons explained below, I deny plaintiff's motion. The judge's name is June, Joun. Roman 1, District Court Jurisdiction. To begin, I am reluctant to chime in on matters within the state court's interests. There are limits to federal jurisdiction as outlined variously in the Anti-Injunction Act, the Younger Abstention Doctrine, and the Rooker-Feldman Doctrine. At the hearing, counsel for defendants acknowledged these doctrines may or may not be applicable, while plaintiffs disputed their applicability to the case at hand. Subsequently, I gave the parties an opportunity to brief these issues. My review of the doctrines suggests that none of them are applicable under the facts and circumstances of this case, principally because the plaintiffs are strangers to the state proceeding. However, I recognize that the Supreme Court has held the various types of abstention are not rigid pigeonholes into which federal courts must try to fit cases. Rather, they reflect a complex of considerations designed to soften the tensions inherent in a system that contemplates parallel judicial processes. Yeah, this is the ruling on the buffer zone. The federal court ruling on the injunction for the buffer zone. The court, Cannoni, the state court, has expanded the buffer zone from the 200 feet of the prior trial to extend to an area a little bit further out. It's really kind of unclear. There are a couple of streets that it border, and there are a couple of private businesses in there, including restrictions on clothing. Thank you. Kindergarten cap. Without deciding this jurisdictional tension, I proceed to address the merits of the plaintiff's claims. 2, temporary restraining order. The standard for issuing a TRO, an extraordinary and drastic remedy, is the same as for a preliminary injunction. Plaintiffs must show that weighing the following 4 interests favors granting a TRO. 1, the likelihood that the movant will succeed on the merits, the possibility that without an injunction, the movant will suffer irreparable harm, the balance of relevant hardships as between the parties, and the effect of the court's ruling on the public interest. A, likelihood of success. I begin with the likelihood of success on the merits, which is considered the most important of the 4 elements of the sine qua non of the calculus. Plaintiffs allege that their First Amendment rights were violated by Judge Cannoni's second buffer zone order because it is content-based, not narrowly tailored, and constitutes prior restraint. Plaintiffs further argue that the second order was issued without a meaningful opportunity to be heard and constitutes a vague, unconstitutional regulation. In contrast, defendants argue that the buffer zone created by the second order is content neutral, a content neutral time, place, and manner regulation narrowly tailored to serve a significant state interest, and that plaintiff's due process claim is based on the flawed premise that they were not granted an opportunity to be heard. Based on the evidence before me now, I find that plaintiffs have not demonstrated a likelihood of success on the merits of their First Amendment and due process claims. They basically wanted the federal court to vacate temporarily the buffer zone order, and the federal court is saying no. Hang on. Number 1, First Amendment claim. In relevant part, the second order states, No individual may demonstrate in any manner, including carrying signs or placards within 200 feet of the courthouse complex during trial of this case, unless otherwise ordered by this court. This complex includes the Norfolk Superior Courthouse building and the parking area behind the Norfolk County Registry of Deeds building. The buffer zone, here's the further areas. The buffer zone shall further be extended to include the areas bounded by Bates Court, Bullard Street, Ames Street, and Court Street. Individuals are also prohibited from using audio enhancing devices while protesting. The second order is almost identical to Judge Cannoni's April 4th of 2024 order establishing a buffer zone during the first state court trial in the Commonwealth v. Karen Reed, which is the first order, Roman 1, which says, in relevant part, the first order states, no individual may demonstrate in any manner, including carrying signs or placards within 200 feet of the courthouse complex during the trial of this case, unless otherwise ordered by this court. This complex includes the Norfolk Superior Courthouse building and the parking area behind the Norfolk County Registry of Deeds building. Individuals are also prohibited from using audio enhancing devices while protesting. So you can see she extended it to these other areas bounded by Bates Court, Bullard Street, Ames Street, and Court Street. And that's what this court says, that's in that case, the Massachusetts SJC held that the trial judge struck a balance between the right to protest or demonstrate and the defendant's right to a fair trial. I agree with the SJC's reasoning and find that plaintiffs have not demonstrated a likelihood of success on the merits on their First Amendment claim, even despite the extension of the first order to the area bounded by Bates Court, Bullard Street, Ames Street, and Court Street. A, constitutional standard. The First Amendment applicable to the states through the 14th Amendment prohibits the enactment of laws abridging the freedom of speech. The Supreme Court, however, has regularly rejected the assertion that people who wish to propagandize protests or views have a constitutional right to do so whenever and however and wherever they please, citing U.S. v. Grace. In a traditional or designated public forum, content-neutral restrictions on the time, place, and manner of expression must be narrowly tailored to serve some substantial governmental interest and must leave open adequate alternative channels of communication. If the restriction is not content neutral, then it must satisfy strict scrutiny. That is, it must be the least restrictive means of achieving a compelling state interest. B, content neutrality. The parties do not dispute that the speech at issue is protected by the First Amendment and that the location at issue is a traditional or designated public forum. Instead, they dispute whether the second order is content neutral. Here, the second order bars all demonstrations within 200 feet of the courthouse and within the extension, regardless of the subject matter of the demonstration. It does not draw content-based distinctions on its face. To determine whether a violation of the second order has occurred, one need not examine the message it conveyed. Rather, whether plaintiffs violate the second order depends not on what they say, but simply on where they say it. Significantly, any protest against the defendant and in support of the Commonwealth would be equally subject to the restrictions of the buffer zone. Footnote number 2, which was the first case, Spikuza, that was during the first trial. Footnote number 2 says, plaintiffs are similarly unlikely to succeed in their assertion that the second order constitutes prior restraint. I agree with the SJC that there is no prior restraint where the buffer zone order does not forbid protesters and demonstrators from expressing their chosen message. They simply must do so outside the buffer zone. Similarly, the second order does not forbid speech activities, but rather limits where the speech can occur and thus does not constitute prior restraints. Plaintiffs argue that the second order is not content neutral, because it specifically prohibits demonstrations. It does not prohibit commercial or other types of speech. Here, to accept plaintiff's claim would be to classify virtually every injunction as content or viewpoint based. An injunction by its very nature applies only to a particular group or individuals and regulates the activities and perhaps the speech of that group. It does so, however, because of the group's past actions in the context, I just lost my place, of a specific dispute between real parties. The parties seeking the injunction assert a violation of their rights. The court hearing the action is charged with fashioning a general remedy for a specific deprivation, not with the drafting of a statute addressed to the general public. Furthermore, nothing in the record indicates that the second order has an incidental effect on some speakers or messages, but not others. And even if it did, such effect does not render the second order content-based. Thus, I find plaintiffs are unlikely to succeed on their claim that the second order is content-based. C. Narrowly tailored to serve a significant governmental interest. Even though the second order is content neutral, it still must be narrowly tailored to serve a significant governmental interest. For content neutral time, place, or manner regulation to be narrowly tailored, it must not burden substantially more speech than is necessary to further the government's legitimate interests. As stated previously, the second order encompasses the area established in the first order. Here, the trial judge reinstated the buffer zone in that area for the same reasons as the first trial. Quote, for the same reasons that compelled the court to establish a buffer zone for the first trial, it is necessary to establish a buffer zone for the second trial to ensure the defendant's right to a fair trial. I agree with the SJC's reasoning that the original buffer zone area passes constitutional muster. Yeah, Melisa says, support local small businesses when we are there. Agreed. The buffer zone will help ensure a fair trial, a significant governmental interest by physically clearing the path for jurors, witnesses, and other individuals to come and go from the courthouse complex without obstruction or interference by protesters or demonstrators and any concomitant intimidation or harassment within 200 feet of the courthouse complex. The buffer zone also helps protect the jurors who, as the trial judge noted, must remain fair and unbiased from extraneous influence that might result from, for example, viewing pictures of putative evidence directly in their path. The buffer zone does not preclude the petitioners or anyone else from engaging in the same forms of protest they have previously done. It simply constrains them from doing so within a limited zone tied to courthouse property. In so doing, it leaves open ample or alternative channels for communication of the information. One of the problems that I think is happening is that the buffer zone areas are not defined, right? Aren't people out there like, we don't know where the buffer zone is? And so we don't know if we're crossing into it on a certain side of the courthouse. Like, is it even, are there barriers up? Is it gated? Are there signs up? Is there, any sort of caution tape around the buffer zone so people know when they're crossing over it? I don't know. Additionally, the extension does not burden substantially more speech than is necessary to further the government's legitimate interest, the defendant's right to a fair trial. The state has a legitimate interest in protecting its judicial system from the pressures which picketing near a courthouse may create, and it is of the utmost importance that the administration of justice be absolutely fair and orderly. Judge Cannoni found that during the first trial, the collective voices of groups of demonstrators gathering outside the buffer zone and vehicles honking their horns in response to demonstrators could be clearly heard inside the courthouse, despite the original 200-foot buffer zone. An anonymous juror from the first trial detailed how they could hear protesters outside screaming and yelling from the deliberation room during the first trial. Where there are groups protesting in front of the courthouse that can be heard in the courtroom, such actions may be presumed to intend to influence judges, jurors, witnesses, or court officials. According to an affidavit by MSP Sergeant Michael Hodman, the original buffer zone was sufficient to prevent disturbance from the southern, eastern, and northern side of the courthouse. However, significant noise and honking originated from the western side of the courthouse, which has larger open spaces. They gave out a bunch of honking tickets as well, didn't they? Such honking was in response to signs and gestures from demonstrators. As a result, the trial judge expanded the buffer zone to directly include those specific areas west of the courthouse. In other words, the extension directly advanced the goal of ensuring a fair trial. That second order is in effect during a limited time frame, the course of the criminal trial, demonstrates narrow tailoring. Significantly, plaintiffs may still engage in the same forms of protest outside the buffer zone. In sum, the extension is limited in scope and time, clearly tailored to ensure the defendant's right to a fair trial, and continues to leave open ample alternative channels for communication of the information. Such safeguards are necessary and appropriate to assure that the administration of justice at all stages is free from outside control and influence. And while you might not like this decision, it is in accordance with the law. So I don't know that there's much to be done from here, but we're going to keep reading. Plaintiffs argue that the second order was not sufficiently narrowly tailored. For example, plaintiffs argue that any restriction on demonstrations should only be during jury selection. Jurors could be brought through through alternate entrances, and where there may be reasonable buffer zones enacted, demonstrators could be asked to turn away from a juror or witness until that person enters the courthouse. Contrary to plaintiffs' assertion, the second order need not be the least restrictive or least intrusive means of serving the government's interests, especially here where the extension served the legitimate interest of ensuring a fair trial. Yeah, exactly. Dawn says, can I just say one anonymous juror who protested, but 5 jurors said innocent on charges and 1 and 3. Yeah, I know. I know. It's crazy. Mm-hmm. But, understand also that all of this, if they can hear people outside, it could work against Karen Reed too. It could work against her just as much as it could work for her. So I don't know that this is a horrible, horrible decision, because it could really work against her. And so, it's my opinion. Thus, because the second order is content neutral, narrowly tailored to serve a significant government interest, and leaves open ample alternative channels for communication, plaintiffs have not demonstrated a likelihood of success on the merits of their First Amendment claim. And that's what this federal judge says. Number 2, due process claim. At a minimum. So we only listen to jurors when it's beneficial to the Commonwealth. Kinda. Yeah, kinda. Mm-hmm. Need to know says Dedham residents in that area are pissed off. Those for and against Karen. Yeah. Everybody's angry. Everybody's angry. Yeah, I know that Ruby is here. I was talking to Rubia before. Is that what you're talking about? When I'm reading, though, I can't watch the chat, so it's hard because, this document's like really small font and I have to enlarge it, and then I don't watch the chat. Am I missing something? Hold on. Okay. Well, they haven't really shut the protesters up. They're allowed to protest or support. The supporters are allowed to support. They're just not allowed to support right in front of the courthouse where the jurors are walking in and out. And quite frankly, they could be intimidating either side, right? They could be. And I heard, and Kurt is the constitutional lawyer, and Kurt went over this at length. Seems to think it is in line with the Supreme Court decisions. Yes, Kurt? I see that you're there. At a minimum, due process requires that a party be given adequate notice that its conduct will be the subject of a binding judicial determination, and that it be afforded an opportunity to be heard. Rubia says, I think it's better that they're not right in front of the courthouse. We shouldn't have anything interfering. Yeah, I mean, because it could go for or against her either way. John O'Keefe was not hit by a car, and a car did not hit John O'Keefe. So, yeah, and right. Well, John's mother crying her heart out feet away, right? She's there. Some judges don't allow any open display of emotion. We've seen that in Florida. We've seen that in a lot of other cases, but she hasn't admonished anyone for showing any emotion in this courthouse, and she is going to allow the Alberts and McCabe's to come in if they want during closings. So there's that. Yeah, Mistress G says hit the like button if you want a free Karen Reed. And Brittany says, I feel like it would be a different issue if the jurors couldn't hear the protesters in the jury room at the last trial. Right. All right, moving on. Here, plaintiffs argue they were not provided a meaningful opportunity to be heard, but do not point to any facts to support their assertion. Rather, the record indicates that the trial judge heard from the community regarding the Commonwealth's motion for a buffer zone and that local merchants made requests specifically pertaining to that motion. Such opportunity to be heard is further affirmed by the second order, which indicates the trial judge recognized the list of concerns sent to the court by the Karen Reed Trial Prepare Together group of local business owners and organizations that experienced issues with protesters during the first trial. Significantly, there's nothing in the record to indicate that the trial judge restricted the plaintiffs from voicing their opinions prior to the issuance of the second order. Thus, plaintiffs have not shown a likelihood of success on their claim that there were no procedures in place to provide those impacted by the second order with an opportunity to contest it. Plaintiffs also argue that the second order is a vague, unconstitutional regulation. It is established that a law fails to meet the requirements of the Due Process Clause if it is so vague and standardless that it leaves the public uncertain as to the conduct it prohibits. She did. That's right, Lisa. You're right. She scolded Cindy Chesna in this courthouse for crying Cindy's husband was killed in the line of duty, right? And didn't that Chesna trial also result in at least one mistrial, maybe two, right? And did she also bust the jurors in from another county? Right. Right. And that's a heads up that the Alberts and McCabe's will be at the closing. Moving on. Plaintiffs also argue that the second order is a vague unconstitutional regulation. It is established that a law fails to meet the requirements of the Due Process Clause if it is so vague and standardless that it leaves the public uncertain as to the conduct it prohibits. Here, in relevant part, the second order identifies the action prohibited with specific examples. No individual may demonstrate in any manner, including carrying signs or placards. The second order clearly identifies the area where protesters are prohibited from demonstrating within 200 feet of the courthouse complex, including the Norfolk Superior Courthouse building and the parking area behind the Norfolk County Registry of Deeds building, as well as the zone of the extension, the area bounded by Bates Court, Bullard Street, Ames Street, and Court Street. Finally, the second order specifies how long it will be in effect during the trial of this case. Thus, it is clear what the second order as a whole prohibits. Speculation about possible vagueness in hypothetical situations not before the court will not support a facial attack on an order when it is surely valid in the vast majority of its intended application. And that is footnote 3, which says, I need not reach the remaining factors, irreparable harm, balance of the equities, and public interest, where plaintiff cannot demonstrate likelihood of success on the merits. And citing some case law. Conclusion: for the reasons stated above, plaintiff states motion for temporary restraining order is denied. So ordered. XO, Judge June, U.S. District Judge. Hang on a second. So that is denied. But remember, this was not Karen's motion. This was a motion made by a couple of citizens, Jason Grant, Allison Taggart, Lisa Peterson, and Samantha Lyons. Will they appeal this to a higher court in the federal system? That I do not know, unless anybody has any information on that. Sassy Vice says, I'm so happy to live on an island in Canada. Y'all done gone mad in America. LOL with love. LOL with love. Well, this CPU mod one says, when will Karen ever get a win from the powers that be? This is not Karen's motion. So this is a loss for the people of the of the state of Massachusetts and others who would like to protest right outside the courthouse. But this is not a loss for Karen. And I also think that all of these people right outside the courthouse, quite honestly, could work against Karen. And so we kind of do want to have a fair trial for Karen, don't we? CPU Mod 1 has been here a lot longer than 2 months. My question is, how do we know who gets called first as far as the witnesses go? Love you with all of my heart. I don't know that they have to give an order. I think they're allowed to call them in any order that they want. I think the first trial, the Commonwealth called Paul and Erin O'Keefe. I think were the first 2 witnesses, right? Do you guys remember that? I think that is, those were the first 2 witnesses. Thank you, Mrs. Bouquet, for my company. Thank you for being here. Snark and Sass, let's go. Let's go. Catco is here. Thank you for your super sticker. And nothing to see here. If they can't wear pink, change to purple. I'm confused. How can they tell private businesses what they can do? That's their ruling. Time, place, and manner restrictions are okay under the Supreme Court of the United States of as such America. And they are going to decide, or maybe there's going to be a conference on April 25th with regard to whether or not the U.S. Supreme Court or SCOTUS is going to hear or take up Karen Reed's petition for certiorari based on the double jeopardy claim. I'm going to also tell you that the U.S. Supreme Court agrees to hear approximately 1% of all writ of certiorari petitions that are put before it every year. And so the chances are slim. However, I mean, if you want me to say there's a chance, I guess there's a chance. But you got to be ready for trial no matter what. And so you just got to be ready to go, ready to go, ready to go. Let's see what Christina Rex is saying, if she has anything further to tell us about from the courtroom. No, not much. I mean, we don't know if opening statements are tomorrow. We don't know. As of right now, it's tomorrow. Some people are saying it may be Wednesday, but again, there's a lot of bad information, not bad information, just not correct information out there. So I don't want to tell you anything that I'm not 100% sure on till I hear it from somebody who knows, who is in the courtroom, and what the actual judge says. Loudmouse, what if you're wearing a plain pink t-shirt? I have pink on right now. They're going to dictate what color clothing that can be worn. All this is doing is making Bev hate Karen more. No, I don't think so. As if that were even possible. Exactly. I don't think so. Thanks for your super chat. Did you see the audit company roasting the Canton audit? I saw something about that in passing. I don't really know like who they are or what they said or if that was like something they publicly posted. But I did see it in passing, Life of Deshaun. So thank you for that. Jess made it in. Okay, good. Let's see what Jess has to say. She was on the standby list. There's a standby list. Like going to Saturday Night Live for the taping and hoping somebody doesn't show up so you get in. She is seated in the courtroom as of 4 minutes ago. And so there's that. Craig Bates has been spotted in the courtroom, and we're very happy. So we really don't know anything more than that. Let's see if anything else has landed in my inbox to see if there's any other decisions that we can talk about today so far. Okay, hold on. Talk amongst yourselves for a second. Thank you, Mastad, for this, but I don't know if there's anything in there that I'm missing right now. There's a lot of documents in there. I can't specifically see them or know which ones I have not gone over, but I think we have gone over. Can you wear pink underwear? Yeah, I don't know. Aiden won't be there this week, right? He didn't make the cut, or I think he forgot to. He forgot to put in his application or something, right? So I don't know. I don't know. Yeah, I just got the seat because she was on standby. There's only 10 seats for media. each week, and they're doing some sort of weird lottery system. So 10 are selected each week, and they sit at a high top behind the victim's family, who is facing Karen Reed. There are 10 seats for the victim's family and friends, and then there are 10 seats for the Karen Reed family and friends, and that's it. That's how small this courtroom is, and that's it. Yeah, so if Jess is in, Grant must leave. Yeah, I think she's got a restraining order against him. So I think that's, I wonder if he had to leave because of that. So many shenanigans are going on. So many shenanigans are going on. What is going on outside the courthouse? Do we have any boots on the ground outside the courthouse that are in the chat? If you're there, let me know. Anything with the Commonwealth proposed stipulations? I haven't seen anything on that, Stina G. No, I haven't. I'm sure that they were just like, yeah, no, we're not going to agree to that. They wanted the defense to agree to all kinds of ridiculousness. Right. Young Black economist said that lawsuit was denied. In my opinion, the people should not be too disheartened. SCOTUS rules in favor of the school. Bong hits for Jesus. That's the law. Court can set temporary rules about signs, right? Time, place, and manner restrictions. Exactly. I think the Glairer is in town. I saw him on the Tom CPU stream this morning. And somebody's saying F Bev, we will just be louder. I don't know. Look, there's a lot of stuff that's going on out there that people think is helping Karen Reed. That's not helping Karen Reed. So I'm just going to put that out there as just to like guide your actions accordingly, because there are a lot of shenanigans out there, and it's not helping. Some of the stuff out there is not helping. It's just not. I mean, I want to call it like I see it. Nobody wants to see Karen Reed acquitted the way I do, because John O'Keefe was not hit by a car. That's how easy it is. This case is about the injuries. It's about the injuries. Catco, huge fan. I feel I must tell you about Billy Tibbetts as a convicted rapist from my hometown. Don't want people thinking that you stand with him. No, I don't stand with him. I didn't know that. Is he a hockey player? Because when I Googled Billy Tibbetts, there's like more than one. I didn't really find any information about him. So that's terrible. I don't stand with him at all. That was just a tongue-in-cheek joke from the first trial when people were on the Zoom and Clerk Jim didn't know how to mute the Zoom call. That's what that's from. But thank you for telling me that, because I did not know that. Thank you, Lori. It says Trial Rage 2 Wellness Group. We should put out a daily anxiety coping sealer exercise or meditation phrase like, whenever Hanky's speaking, you must get out of your seat. Yeah. You know what, Lori? Thanks for the memo. I said that yesterday. Everyone should get like a little cup of ice cubes. And every time something starts to give you anxiety, hold an ice cube in your hand for as long as it takes to get you distracted from what's going on. Thank you, Marjorie, for your cash app. Very much. I appreciate you. And Chief Sherry is here. Thank you, Sherry, for your boop. Memo Sherry says John O'Keefe would have to be a Chuck Norris student to kick that taillight with a flying kick. Oh, and his sneakers wouldn't break that polycarbonate. No, but that's how that woman wants you to think. That his sneaker came off. So there's that. You can't make this up, right? Can you make it up? No, you just can't. You absolutely just can't. Thank you, Catco, for telling me that. Sue says, is there any interest in watch parties? If so, please contact me. Locations TBD depending on response. I don't know. I don't know how people are supposed to contact you, Glamour but thank you for your 5. And I don't know what you mean by watch parties. And unless you're watching my stream, I won't allow it. So, so there's that. Clara went to standouts yesterday. Oh, that's nice. And JFK too. That's so cool. And CPU Mod 1, who is Tom CPU's sister, says, I do agree. Some of the stuff outside the courthouse is not helping. The whole thing is a very fine line. Right. And are people showing up on the other side, on the stone Karen Reed to death before you hang her in town square side? Are they showing up? So I don't know. I do not know. I just do not know. You are not out there, so don't comment. Are you talking to me? Are you sure you're talking to somebody else in the chat? Could we even count the shenanigans going on just since Hank Brennan has been here to try this case? No. Why do they need a hired gun? Why do they need a hired gun? They don't. Kurt says, Melanie has an unflappable calm thing going. I need to learn how to channel more of that in my own life from my own side. No, I rage quit. I rage quit the other night when there were people in the chat that were saying it's okay for men to hit women. It was beyond. I rage quit, and I wasn't upset about it. I mean, I'm not mad about it. That was during the Turk verdict, where Dr. Turk choked his wife to death after she had a restraining order on him. And then Kevin Reddington said that the restraining order was bogus, and yet he did wind up choking her to death, so there was that. And there were people saying that it's perfectly okay to hit a woman. And that was wild. So I rage quit. And so I'm not as calm as you may think all the time. Yeah, my head was still rolling around downtown Manhattan. That's right, Santini. That's right. It's the Andrew Tate fan club. Sarah Clancy, it should bother people that were paying Hank Brennan, but also the fact that we're paying Lally and a woman lawyer to basically sit. Oh, and not only Sarah Clancy, are you paying Brennan? I mean, but you're paying his paralegal too. So his paralegal is also being paid by the Commonwealth. And there's that. And we think that his paralegal hates him because she spelled his name Breenan one time. My name is Hank Breenan. Hold on, we have a little name tag for that. Hello, my name is Hank Breenan, because that's how he introduces himself. Like he's like at a sales conference somewhere in Vegas or Orlando, and he's wearing a red name tag. Yep. Jennifer C. says, if John's family believed that he made good choices in Friends, you can understand his parents' unwavering belief that his friends did not do it despite the botched investigation. You know what we were talking about the other night when we were going over like Rubia's theory of the beating and Dr. Stonebridge's testimony? And I said, does anybody have that clip of Brian Albert boxing on Boston's Finest? And one of you sent it to me, and now I can't find it. There is a clip. I think Turtle Boy has it on his channel. Let me just see if I can find it. But if anybody knows exactly where to find it, like right now, can you send me a link to it at fanbase@mlittlelaw.com? Because I think it was on Turtle Boy's channel. And it like shows Brian Albert like literally taping up his hands and getting ready to like get in the ring, right? Yeah, that was me, Carrie. I'm like, yeah, I have better things to do with my Friday night. Bye. I was like, yeah, I'm gonna go do something more fun. Do something more fun. It was Thursday night, right? Because it was prom night. I remember, and it was a pink moon last night. It was a pink moon. The full moon was pink on Saturday night, and we said that was the free Karen Reed. The free Karen Reed moon. Remy says, I don't think John was actually friends with the Alberts. Knew them for sure, but friends. No one was going out to brunch Sunday mornings all together. No, I think Brian Albert in his testimony said that he met him twice before this. And he met Karen once, like at the waterfall, right? Before the night of. Leslie said she'll allow a meltdown. Thank you, Leslie. It was I felt it was warranted, and I'm not sorry about it. So yeah, they do a prom on Thursdays sometimes because and then but they had off on Friday, so no big whoop. VM10, his friends who made him think taking kids to Dunkin' Donuts is a bad thing, and he's raising them wrong. Yeah. I did watch AV with Andrea yesterday. I thought it was great, JB. Did you watch my show with AV? That was really good too. I taped something yesterday with Larry, the DUI guy. So whenever his editor gets it done, I guess he's going to put it up. So keep an eye out for that. It's Bittersweet has said they were not his friends. He was going to go quietly alone with their corruption. And he would have called them on it. He fought back. That's why they hid Colin. Brian Albert never came out. Thank you, Zatat. You win. Ding, 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 ding. You guys are so collaborative. Okay. So we're going to play a little clip. And if it gets cut out on replay, it's because, it won't be Turtle Boy that strikes me, but who knows if this is like Boston's Finest. Like, I don't really know. But let's see. Here's a clip in which Brian Albert is featured in that reality show called Boston's Finest. Hold on. Haven't watched it yet, so let's take a look at this. Because I said, is he a trained fighter? Because, all the brain injuries to the frontal poles and the temporal poles, right? And the giant gash in the back of the head. And we went over like the number one cause of fatalities in professional boxing is what? Subdural hematomas. Okay, ready? Here we go.
Take care, brother.
So he's used to dealing with dangerous people, right? He's used to working undercover. He was like in the fugitive task squad unit or whatever the hell they call it. And yet, when his sister-in-law pulls up to his house and sees a dead cop on his lawn, who happens to be her dear friend, John O'Keefe from 10 years, she doesn't run inside the house to make sure that her sister and the rest of the family is not also dead, right? Explain that to me. He's in the land of dangerous people. This is the world in which he lives. Bong Hits for Jesus is one of the best case names ever. Yeah. That's awesome. All right. So here, watch and learn and say to yourself, is this reasonable doubt?
Going out, posing as buyers.
That wasn't very long.
Well, I have been following the camera.
Hey, Billy Bush. What's up, Billy Bush? Oh, that's so funny. That's Billy Bush's clip of with him with Peter Murphy. Yeah, so this is only a 34-second clip, but right, posing as buyers, like that's not dangerous work. He was in Desert Storm. I did watch the one with Peter Murphy on Billy Bush. I did. I don't want to play it though, because I don't want Billy Bush to strike me. Although I do want Billy Bush to call me. I want to go on Billy Bush's show. That's what I want to do. Wasn't Jen a coach? Says Zoe. Wasn't she? Why wasn't she trained in CPR? I wouldn't want my kid playing for a coach that hasn't taken a basic CPR class. I don't know that she wasn't trained in CPR, but I do not think she tried to do CPR on John O'Keefe. Carl Steinbeck did a Will just said that playing the clip got him dinged. Oops. All right, I'm gonna have to go back and cut that out. So if you're just joining, we watched a clip that we probably have to cut out after this, but I talked over the whole damn thing. So I don't know. Lori said, I think supporters should wear tie-dye since ruled not to wear pink. Tie-dye represents freedom and peace. And Karen deserves both. Yeah, that is true. That is true. So if you're on replay and you can't see the chat, that's what happens. If I have to edit the video, the chat disappears. So get all your chatting in now, just in case. And John O'Keefe was the punching bag that night, says Gigi. Gigi? Thank you, Lori. Thank you, Lori, so very much. Tina says Karen's family needs to be given the O'Keefe seats. I think that in the Penny McGee trial, the benches were flipped for the sides, the bride side and the groom side, as we like to say, because, you know, it's like church and they are like pews, but that was a bench trial. And so maybe they have the right to face the jury. I don't know. Hi, Andrea, fighting my anorexia. One live at a time. We're here for you. We're praying for you, Andrea. I'm so sorry that you're going through this, but you got this. You're a fighter. You're a warrior. You got this. Lori, thank you so much for your super sticker. And Lori says, I think supporters wear tie-dye. Got it. I mean, who doesn't love tie-dye? I love tie-dye. Half my wardrobe is tie-dye. I'm a deadhead. I know. I feel you, girl. All right, we might as well end now because, you know, I'm probably going to have to cut off that end of the stream. So as I say goodbye to you, let's just make sure you have all your notifications set so that if something else drops, we can come back and cover it. Because as soon as we find out more information, we're going to come back and we're going to let you know what's happening for tomorrow, or I will put up a community post. And so there's that. Thank you to the moderators for keeping it classy this morning. 2.5 hours is wicked short for us. Usually it's like 4, 5, 8. Because when we hit trial days, you guys, we go all day long. We go all day long. We get the snacks. We have everything. Go buy your popcorn. Get your snacks ready for the week. Get DoorDash to deliver you a whole bunch of Gatorade or whatever else it is that you drink. Some cruelty-free chapstick. We learned that bitch sticks, according to Queen Tennessee is the best. Bitch sticks, BITCHSDIX. They donate all of their profits to survivors of DV, and also it is organic. So there's that. Thank you, viewers, replay viewers. Please share the stream out. Please hit the like button because it does help the channel. And as always, stay cool, stay kind, stay classy. I will probably see you real soon, probably later today. So peace out, my friends. Until next time, goodbye.